ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸಿಟ್ಟಿಂಗ್ ಇಲ್ವಾ ಇವತ್ತು? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸಿಟ್ಟಿಂಗ್ ಇಲ್ವಾ ಇವತ್ತು?
Civil contempt notice has been issued to the accused. They have not filed any complaints about it or they have not intimated what has done in the direction of this.
It is an old matter.
23 minutes. Old matter. Notice has been issued to the accused.
Date must have been given.
Yes.
Some date must have been given by the court.
No, date hasn't been given, but that has been overlooked. It was in the 2003, November 2003.
23rd,
Thereafter, it has not been.
23rd.
My lords, I am party in person. My case is urgent for a long date. I want early date. I am party in person. It is at the stage of for orders on office objections and submissions, my lord. Please, my lord. I want early date. Please, my lord.
What is the urgency?
It is writ appeal, my lord. Writ appeal, my lord.
What is the urgency?
2510, my lord. I am Mahaswamiji, my lord. I am senior most district judge, my lord.
What
The
is the subject
superintendent
matter?
provision has
Unless
been
you,
refused to
unless you
sanction,
tell
my
the
lord.
subject matter, and urgency will not circulate.
Please, my lord. My batchmates are in the high court, my lord.
What is?
My batchmates are in the high court, my lord. My seniority is lowered, my lord. My superintendent scale promotion, my pay scale is stagnated, my lord. Please, my lord.
24th.
No, it is deferred, my lord.
24th.
Please, my lord. Please, this month, my lord. Thanks, my lord.
Mr. Party in person, date is already fixed in your matter.
My lord.
So I will not change it unless you file IA. That is the rule. Which date is fixed?
25th October, my lord.
October. And you file IA to prepone. If you want to
Please, my lord.
prepone.
Please, my lord. I will.
Once the judicial order is passed to give a date, we will not change it without IA.
Please, my lord. I will.
Subject
file
to
it.
you, subject to you making out a case, we'll prepone the, if
Please,
found fit.
Please,
Yes.
my lord.
Lord's kind permission, on student matter, education matter, counseling has been notified to start on the 20th. This is post-graduation matter, my lord. My lords have already held in the judgment which was delivered that the condition regarding citizenship will not at all apply. This is postgraduate counseling, undergraduate is over. Now, postgraduate counseling has been notified. They have said that will not allow you to participate because government has not amended the rule. That is what their affidavit said. And they are saying unless there is a court order or we receive from the government instructions, will not allow you to participate in the council. I have given a representation. Therefore,
Same.
my lord, the
Same.
counseling is starting on 20th.
Same category,
My lord.
same category.
No, this is not Hyderabad. This is general.
No, but OCI got,
Okay, yes, OC, but not Hyderabad, Karnataka.
but their stand was clear in the affidavit.
Yes, that they are saying it applies only to undergraduate.
You want
This is-
circulation of the matters?
My lord.
You want circulation of the cases? What do you want? Listing of the case?
Listing, fresh matter. Listing, my
When?
lord. If it can be taken up day after tomorrow, my lord.
Tomorrow.
Oblige.
May I make one matter, my lords, it's a cement manufacturing industry. Lease has been granted from 66, it's been going on. There is a dispute between us and the State Department, my lords, regarding arrears of royalty they have demanded. We have approached the revisional authority, central government, they have passed an order, resolve the issue. Now it's being precipitated and my industry is coming to a close. Can I request, it's a fresh matter. We have filed a writ petition, my lords, since they are now demanding arrears of royalty and also not executing the supplementary lease deed. If it is possible tomorrow or day after, otherwise, my lords, 24th. There's some urgency, that's why I'm keeping
If there is a real urgency, then yes, otherwise on 19.
24th, my lord. I'm not in the country between 15th to 21st.
24th.
24th.
That is very good. 24th, yes.
My lords, this is a writ appeal.
Lords, kindly, serial number 22 is a medical education contempt matter, my lords. Today is the last date for option entry,
the number.
second round. First round, they did not permit me despite this honorable court's direction. Second round also, they have not notified me, 72, my lords. Contempt in medical education matter. Your lordship,
72.
72.
My lords,
Despite-
Give 72.
deserve my.
Anybody appears?
My lords,
Contempt, it's still notice is not issued. My lords, orders at our page 46.
Page?
46.
That operative
The
is,
portion is at page 70, my lords.
yes. It is the
That's
sport, that sports quota.
The sports quota, my lords. First round also, they did not invite me, nor notified me. Despite repeated this one, first round, they allotted the seat to some other candidate. Though I had
Yeah.
written a letter to principal secretary, who is a party to the proceedings.
Yes,
my
ma'am.
lords,
We have reserved one seat, my lords.
There is a clear direction to admit.
Lords, may I make this submission? We have reserved the seat.
There is a clear direction to admit.
Lords, he has not taken, the student has not taken the NEET examination this year. As per the NEET reg. My lords, we have complied, my lords. I have just obtained.
There is a clear direction to admit. In contempt, we do not, our eyes are blind, our ears are deaf, except we listen to the order, except we see the order. If you want to challenge, you challenge it, but you admit first. Otherwise, we'll hold up the person who is responsible. who is-
May be called up tomorrow, my lords. It may be called on tomorrow, my lords.
No, 2:30, you take in instructions, 2:30. Then
Well,
we'll see if you are unable to, then tomorrow.
Grateful.
My lords, this is a writ appeal, my lords. This is regarding a transmission line that is being constructed from Karnataka to Kerala. The construction has already started, my lords. Kindly, if the matter could be listed. There's an urgency. Almost 50 families are going to be displaced because of this, my lords.
PIL,
A writ appeal, my lords.
what is the urgency?
My lords, construction of the transmission line has already commenced, my lords.
Construction of
Transmission line, my lords.
transmission line,
Yes, my lords.
it can wait. 19th.
Please, my lords.
Lords, this writ petition is filed retrieving sum of almost rupees 2 crores from the respondents. I'm for the petitioner. So 8,000 metric, I'm a dealer in iron ore. 8,000 metric tons was seized from me and it was sold, my lords. So out of the sale proceeds, rupees 2 crores is accrued. Now what has happened during the pendency, my lords, another e-auction notice has been served to me by the respondents.
File IA then. File
We
IA.
have filed, my lords. The urgency is that the auction is today. So it,
Okay, then you are mentioning last moment. What-
my lords, no, we had filed the IA. My colleague had also, so please, the urgent, it kindly may be taken up at 2:30, my lords. I'll address the arguments.
2:30 will not, tomorrow.
Obliged, my lords.
Why you are filing at the 11th hour?
My lords, I apologize. Actually, we'd filed the IA. The representation had been made by us to the respondents. They have not considered that representation.
Alal, I do not know if the auction is pursuant to the direction of the Honorable Supreme Court. Alal,
Supreme Court?
yes, in an order dated 14th March 2024, Alal, there is a direction. Alal, that the survey should be conducted and that there should be an auction of the.
All at 2:30.
Obliged.
My lord, the matter pertains to e-auction under the MMDR Act, my lord. The matter was moved before learned single judge yesterday and it was listed, my lord. The learned single judge has specifically directed the registry to place this matter before your lordship
Why?
after your lordship's approval tomorrow, my lord.
Why?
Because the matter, the e-auction comes under the MMDR Act, my lord. So the matter comes under your lordship.
When the auction is
held
going to take?
tomorrow, my lord.
Tomorrow auction is there.
Yes, my lord, my lord. So we have it tomorrow.
I
Same.
think, pursuant to the orders of the Honorable Supreme Court, I have the orders before my
So
lord.
same auction is tomorrow.
Yes.
So your
E-auction.
colleague says that it is today, you are saying tomorrow.
There is another matter which is coming up before my lord.
Tomorrow
which
you-
is for
Yes.
Tomorrow.
Tomorrow. I think
Auction is tomorrow, my lord. Even
Then
if that matter.
the other council said that it is today. All tomorrow, your matter tomorrow.
Lordship, this matter is pertaining to the tender matter. Yes, it is the
My
tender.
lords, this is with respect to my lords, admission of, for Ayush course, my lords. I've been allotted the seat, my lords, in 2022. My lords, due to my lords, my mother had got a cancer, my lords, I could not admit, I have communicated the same to the department. My lords, now, my lords, I opted to take a seat, my lords, they have placed me under the ineligible list. Now, my lords, the first round of allotment is over, my lords. Now, the second round of allotment by KE has been.
It is only listed today.
No, my lords. For the listing, my lords, at least tomorrow, my lords, at least let me be eligible for the second round is my only prayer.
Tomorrow, how many matter will be able to take?
My lords, the urgency is, my lords, even the first round is over, my lords. I've given a representation, all these things, my lord, still
In the second, in the student list tomorrow.
obliged. Great.
Lordship, this matter is pertaining to tender, my lords. The writ petition was dismissed and only the one operating portion was been, which we have appealed, my lords. Can you take it out tomorrow? No, we are not challenging entire order, my lord. Only the one operating portion which which they have dismissed, we are challenging.
It can wait, 23rd. Yes, anybody? Yes, ma'am.
My lords, it's a WP where it is linked with a WA, my lord, we need to delink with the matter with W.
Pardon?
This is a writ petition which is linked with the writ appeal, my lords. We need to delink the matter, my lord, with WA.
D-link.
Delink.
What is the urgency?
My
D-link
lord,
when
it's impugnated gazetted notification which is aggrieved, which is,
when it will taken up, we D-link it.
my lords, on 13th or 14th.
Listed today? No, no, for delinking it can be listed. Whenever it comes, we'll delink. What is the urgency in delinking? Let both travel together.
Kindly a date may be given, my lord.
No, it is, in the other matter, it is already, some date is given.
I am not aware of. it.
Find out and mention. Okay.
That's okay.
My lords, memo for posting, my lords. My lords, the student is a physically handicapped student, my lords. On
Number?
39 admission, CET, my lords.
Serial number?
My lords, for posting, my lords. Memo for posting, my lords.
You want to list the matter?
Please, my
What
lords.
is the
Matter
urgency?
was listed on 39, my lords, before this bench, my lords. On submission across the bar, that second round would be starting on 15th. The date was given on 13th, my lords. But in the meanwhile, they have notified the second round of listing and today is the payment of fees, my lords.
File IA. File IA. Will not prepone in that way. File some IA showing urgency and
Please, my
prepone.
lords.
Seal number 22, my lord.
20?
RPF for the 22, my lord, seal number 22. RPF for the council for complainant, my lord. She is not well, my lord. They have filed a compliance affidavit which is not completely complied, my lord. She needs a week's time. Council on records needs a week's time, my lord. Kindly have it next week, any date, my lord.
Let it
22,
go
my lord.
After vacation,
After 22, my lord.
16th October.
Obliging.
Serial number 33, Your Honor.
Serial number
Appearing for petitioner.
32.
33.
33.
3. Yeah. My senior isn't well, Your Honor. Please kindly grant some 2 to 3
That
weeks
time,
time.
21st October. It is a PIL. Hold it. 21st October. 10 or to 21st October, as requested by Learned
Thank you.
Advocate. Miss, what is your name? So and so, so and so.
Shravani Reddy.
On behalf of the petitioner.
Yeah.
Yes, miss. Yes, madam.
Your Lordship, the bank guarantee was withdrawn.
Little loud. Mic is in.
The bank guarantee was withdrawn, so I request you to list the matter next week.
What is?
Yeah.
What is the matter?
So
It's the matter.
Not aware, like, pass it on. When you are mentioning, you should know this is the minimum thing, at least you know the subject matter. Refreshment. What is the urgency? You find out and mention tomorrow.
So the bank guarantee was withdrawn. The bank guarantee was withdrawn.
Bank guarantee, it can wait 24th.
So
20. This is contempt 24th.
Your Honor, I am appearing as a party in person. My case is listed at 34 today. In the past 5 sessions also, it has come right at the bottom and never heard. Can I request an early hearing?
So at 11, you can't expect that it will not reach.
Pardon?
At 11 o'clock, you can't say that it will not reach.
Well, last 5, 6 times I have waited the whole day here. It has not come. So
We were not there since last 5, 6 times. Were we there here?
I have been coming.
We were here.
Yes, I have been coming.
We were here.
It was, once it was a different court.
And-
It went to the second court or something.
So things are different.
So if you advise,
don't
I'll wait,
connect-
Your Honor, today.
Don't connect the past with present.
Okay,
Don't mention. Yes, yes.
I'll wait the whole day here.
List number 2, seal number 1. Okay, Puttegoda.
Will issue notice.
Please, my lords.
Why you are
Lords.
not considering?
My lord.
It's physically,
Physically disabled to the tune of 75%. My hands are intact. I have a case of missing fingers. I can hold a case of missing fingers. It is
missing
called,
figures,
it is called cleft hands, my lords.
left hand.
Cleft hands. I will either have 3 fingers or 2 fingers. So it may be this way. It's a cleft, my lords. I can hold a pen. I can hold a knife. I can ride a bike, my lords. My
You are-
mobility is there. Despite that, they have rejected my candidature.
Second respondent.
Now, which course you are seeking admission?
MBBS, please.
MBBS.
Please.
MBBS, my lord, the different parameters, my lord, as far as the Medical Council of India regulations are concerned.
I will take my lords to the rules also.
Where is your certificate?
My lords, my certificate is at Annexure A, please. Page number 17, please, my lords.
Page number 7.
17. 17.
17, yes. Oh. To the tune of 75%.
You also look at this annexure A, my lord. The photograph,
I've seen.
1010. 75% is there. my lord.
My lords, what has happened is there was no medical test that was conducted, my lords, to look into my mobility or strength from the hands, my lords, or the fingers, rather my usage of the same, my lords. The disability rules, my lords, at page number 34, if your lordships would kindly peruse. The guidelines regarding admissions of students.
Page
34, please, my lords. 33 is Appendix H, which reads, my lords, guidelines regarding admissions of students with specified disabilities and the rights of persons with disabilities Act 2016. At the bottom, my lords, there is a tabular format, my lords, where serial number 1 is physical disability.
kahan?
A is
Kahan hai?
at 33, my lords, at the bottom.
Page 33 bottom.
Please, my lords. Physical disabilities, locomotor disability, the extent of less than 40% are eligible. More 40 to 80 of disability are also eligible. Not eligible for medical course, more than 80%. Now in the next page, my lords, the kinds of disability are extracted here. And at the bottom, my lords, the asterisk marks. That will be important, my lords. Attention should be paid to the loss of sensation in fingers and hands, amputation, as well as involvement of eyes in corresponding recommendations to be looked at. Attention should be paid to impairment of vision, hearing, cognitive functions, etc., and corresponding recommendations to be looked at. Both hands, my lords, may kindly mark this, my lords. Both hands intact, with intact sensation, sufficient strength, and range of motion are essential to be considered eligible for medical courses. Lords, I am precisely relying on this point, my lords, because there was never a medical examination conducted by the respondents herein. In fact, if the list is seen, my lords, there are people who have 80% and 100% disability also. I have extracted in my pleadings at page number, commencing at page number 12, 75%, 100%, 82%, 80%, 91%. All of them have been considered as eligible. My lords, under similar circumstances.
What is earlier orders? The very direct. You are seeking admission only to MBBS.
My lords, my name is found at serial number. At page 38, my lords, serial number 92.
MBBS.
No, this one, engineering courses as well as MBBS. Engineering course, I'm held to be eligible.
Engineering, she has to be eligible.
My lords, under identical circumstances, what the coordinate bench of this honorable court has done, my lords, has subjected the my lords, candidate to examination, my lords. Sent them to Victoria Hospital, my lords. I have extracted that, my lords. I mentioned those writ petitions at paragraph 11 of my pleadings.
इससे पहले का ऑर्डर और नोट किया है काइंड ऑफ लेटर लेटर Now, where is that decision not to
My
take
lords,
your?
it is in writ petition, my lords, one of the honorable division bench.
No, their decision.
Sorry, my lords.
You are communicated that you are not eligible.
They have communicated, my lords. Page
Where is
number
that?
38, my lords.
Where is that?
I'm at serial number 92. Page 38.
$92.
Please, my lords.
Ravindran.
Please, my lords. Ravinandan MK.
Ravindran M.
Percentage of disability is 75. For engineering courses, I'm held eligible. For medical, not eligible.
But it will be not.
Heard learned advocate Miss so and so for the petitioner. Learned advocate Miss N.K. Ramesh for respondent. Karnataka Examination Authority who appears upon service of copy of the petition in advance. The petitioner herein aspires to pursue the medical professional course of MBBS. He is a person, the petitioner is a person with disability, having orthopedic oblique locomotor disability to the extent of 75%. It is the case of the petitioner that the limbs of the petitioner are intact to his body. And that he has then this page 11 per Sembracha tick figures.
It's pronounced as brachydactyly. Brachydactyly fingers.
Brachydactyly,
Please.
whatever pronounced, fingers. That is THITI, missing fingers, or cleft, CLEFT hands. The petitioner applied for admission in physically disabled, in the quota of persons with disability. Reliance is placed by the petitioner on the notification dated 4th February 2019, issued by the Board of Governors of Medical Council of India, which is a notification amending the regulations on graduate medical education 1997. Full stop. Appendix H of the said notification inter alia provides the guidelines regarding admission of students with specified disabilities, inward comma, specified disabilities, under the Right of Persons with Disabilities Act 2016, with respect to admission in MBBS course. Full stop. In respect of the type of disability which is described as locomotor disability, it is contemplated in Note 4 of the said Appendix H that person with less than 40% disability are eligible for medical course. It is further contemplated that those who have those who have locomotor disabilities between 40% and 80% are eligible for medical course for PWD quota. That those who have 80% or more than 80% disability are not eligible for medical course. Full stop. It is also stated below the note that where both the hands are intact, with intact sensations, sufficient strength and range of motion are essential to be considered for medical course. The sufficient strength and range of motion, which are considered essential, is a functional part of a person with disability. Full stop. It is the contention of the petitioner inter alia that since the disability, since the permissible range of disability to be eligible for admission in medical course in PWD quota is 40%, is between 40% and 80%, and that the petitioner has 75% disability as above, he is entitled to be considered for admission. Full stop. Attention was drawn to the list of UGCET, public NEET, public veterinary, physically disabled candidates provisional eligibility list 2024 into bracket copy figure set page 36 comma annex ref bracket over, in which the name of the petitioner figures at serial number 92, and the petitioner is treated to be eligible for engineering and BSc nursing course, however, is not treated eligible for medical course under the persons with disability category. Paragraph. Notice returnable on 20th September 2024. Paragraph. Learned advocate for the KEA as well as learned additional government advocate Mr. Hegde, who also appears upon service of copy of the petition in advance, would submit that in addition to the extent of physical disability, assessment of functional disability is also necessary. Full stop. Reliance was placed on the observations of the Supreme Court in Bambania Sagar Vashrambai versus Union of India, which was special leave petition number 18017 of 2023, as well as order passed in SCA number in writ petition number 19242 for 24. Paragraph. Admittedly, paragraph. The case of the petitioner is only quantitatively assessed. Full stop. Any detailed report by the medical expert is not available, so as to assess the disability of the petitioner in terms of functionality and to consider the aspect whether the disability which the petitioner suffers from would impede the course of study in the medicine by the petitioner and discharge of his duties as a medical practitioner upon passing the examination, upon obtaining the degree. Full stop. Paragraph. In view of the an expert reasoning on this aspect is required to be obtained. Paragraph. Now paragraph. In light of the totality of circumstances, while issuing notice as above to the authorities, the court is inclined to issue interim direction as under 1. The petitioner shall be made to undergo an additional a medical examination. 2. Team of doctors shall specifically assess and evaluate the 75% disability of the petitioner, which is an overall disability, specifically in the context of permitting the petitioner to pursue the medical course of MBBS, having regard to the physical requirements needed by the candidate for such course. Next, the team of doctors shall undertake the examination and give detailed report about the functional capacity of the petitioner in above regard. paragraph. It is to be noted at this stage that in Bambaniya Sagar Vasaram by Supra, the Supreme Court in order dated 22/9/23 observed thus. So it is here. The expert paragraph. Learned advocate, learned additional government advocate is directed to ensure that the director of same, bowing and ready.
Oh, please.
Same as ensure director ये पूरा ले लेना. ये कौन सा नोटिफिकेशन? सेम नोटिफिकेशन. Notification. Yeah, the notification. Notification, full stop. Paragraph. The petitioner shall appear before the, when shall petitioner appear before the experts?
In a week
On,
time.
on 17th?
Please, my lords.
On 17th.
Please.
Petitioners appear with a team of doctors which will be constituted as above on 17th of September. The medical board shall submit his report after examining the petitioner on the next date of hearing of the petition. The petitions will be listed on 20th. 20th. Notice written.
20th. May I make a submission, my lord?
ये braceted portion नहीं चाहिए. Whom shall include a doctor who is having doctorate in veterinary branch? ये नहीं चाहिए. आप ले लेना.
But may I make a submission at this juncture? My lord, she has not claimed this during the first round. First round, my lord, she has not. The first round is over now. There were only 7 seats, my lord, in physical disability quota. Those 7 have already been taken. In the event, my lord, if she is found eligible after this thing, then she has to dislodge, based on the inter se merit, she has to dislodge one disability candidate.
In the second round only.
In the second. The second round, there is no seats at all, my lord.
So you record your submission.
Yes.
Beach before that. Learned while notice written learned advocate for KEA would submit that the petitioner did not appear in the first round of counseling.
Yes.
He submitted that the first counseling round is already over and the second round will be
starting, my lord, any day, my lord.
starting at any point of time.
Yes.
Paragraph. Then last at the end of the order. Full stops. It is clarified that since the petitioner has not opted to participate in the first round, comma, he would be considered, if at all, liable to be, comma, in the second counseling round only, and his merits shall be assessed accordingly. His merits and the case shall be assessed accordingly.
Grateful.
So, copy of this order shall be made available to the learned additional government advocate as well as to learned advocate for KEA for its implementation.
Obliged. Grateful.
Yes. Yes. Sports. Yes.
Lords,
Number 2.
sports quota seat, my lords. It was an applicant, my lords, in the year 2023, my lords, I appeared, my lords, the CAT cleared need. My contention was that, my lords, I should be classified as P1. In view of the fact that, my lords, I was successful in an international event, my lords, having secured the gold medal. Lord, my case is that, my lords, I have secured the gold medal in an international event and I should have been classified as P1. As per the norms, my lords, which are applicable.
The norms.
My lords, that has been produced, my lords, as my lords, the annexure to the writ petition. As at annexure L, my lords, it starts at page number 50. The relevant provision is, my lords, rule 9(1) capital B, my lords, of the rules.
So what will apply to you? Which
My
clause?
lords, I'm my lords, a winner of an international event, my lords, having secured the gold medal. My lords, is my case. My lords, as such, my lords, I should be classified as P1.
Where is that?
My lords, may have a look at, my lords, rule 9, my lords, which starts from page number
Rule
59, my lords.
Rule 9.
Rule 9, my lords. My lords, A is in respect of NCC. Your lords may have a look at, my lords, page number 60, my lords. On the left-hand side, that is page number 634, my lords. It starts with, my lords, capital B. The following candidates shall be eligible for selection in the sports category, namely, who have represented the country and won medals, cups in the Super A games specified in Schedule 2 during the 5 years periods of study in Karnataka between 8th to 12th standards. Lord, this is what, my lords, is prescribed.
So
Schedule 2, my lords, is
subclause 1 refers to Super A games and subclause 2 A games.
yes, my lords. My submission is Super A game, my lords. Schedule 2, my lords, at page number 67 may be seen.
Schedule 2 of these rules.
Yes, my lords. Page number 67, my lords.
67.
Yes, my lords. Super A games, my lords, are classified in Schedule 2, my lords, as Olympic Games, World Championships, Asian Championships, Asian Games, Commonwealth Games, and Commonwealth Championships. My lords, my submission is, my lords, I comment, my lord, item number 3, that is Asian Championship. My lords, to evidence, my lords, that I have secured, my lord, the position. Your lords may have a look at, my lords, page number 27, my lords, annexure D2, which is the certificate issue.
Page
27, my lords, annexure D2. Page number 27, if lords kindly see, my lords. It says, my lords, so-and-so is the winner of Team Rapid Games in Girls Under 16 category in the Asian Youth Chess Championship 2018. My lord, this is, my lord, undisputed. My lord, this was not being considered. Only participation was considered, my lord. As such, I made a representation at that point of time and also requested that to be considered. As it was not happening, my lords, I came before this honorable court, my lords, seeking for appropriate directions. For a period of more than 1 year, my lord, the state KEA, my lords, did not file any objections. My lord, on one or the other reason, they took time. And my lord, the matter was getting adjourned. In the meanwhile, my lord, selections also happened. So I filed application for impleading those persons who were selected in the sports category. My lord, that application is, my lord, is pending, but all are served. They have appeared. They have filed counters also. My lord, the state, my lords, now has filed a counter. My lord, saying that that insofar as there is they say, my lord, that there is no material to show that I represented the country and secured the position. Number 2, what they say is it is beyond the cutoff date, according to them, that it is only from 1/6/2018 to, my lords, the June, end of May 2023 that they will consider. They rely upon, my lords.
This is the period of study between 8 and 12.
My lord, my lord, that is what I am trying to say. My lord, my respectful submission is, when, my lord, the rules are clear, it says period of, my lord, study between 8th and 12th. They could not have, my lords, prescribed a cutoff date. And if your lordships kindly see their counter, my lords, the counter filed by the state, as to when, my lords, the circular is issued. After, my lords, the seat is over, my lord, the entrance is over. My lord, when the counseling is about to start, if lords kindly come to my lords annexure R2, Kannada version at page number 17, my lords, English at 18. They issue this, my lords, on 23/6/2023. It's what, my lord, they have produced.
Where is rule 9, page 69?
My lords, in the writ petition, my lords,
15.
it only says, my lords, a period of study, my lords, that is
Page number 16, Lord.
660, my lords.
And where they have received the cutoff date?
My lords, the circular, my lords, at annexure R2, what they have produced. My lords, translation, my lords, English translation at page number 18, my lords. In that, my lord, number 2.
Page 18.
My lords, page number 18, my lords, English version.
Statement of-
Lords, at seal number 2, they say the cutoff date will be taken into consideration only for the sports certificate from
Page,
1st June.
page.
Page number 18, my lords, of the statement of objection filed by the state, my lord. That is, my lords, response number 1, my lords. I'm sorry, my lord, response number 2. My lords, on 2 points, my lords, according to me, my lords, this is not applicable for the reason that, my lord, this was issued, my lords, as late as, my lords, on 23/6/2023. My lords, after, my lords, CET is over, my lords, everything is over, when the counseling is about to begin. My lords, at that time, my lord, this is,
Your claim is for which year?
my lords, for 2023, my lords.
23.
23.
20 to 23.
No, 23/24.
23, 20.
When, my lords, the counseling is about to start, my lord, they issue this circular according to them, my lords, which according to me is not permissible. Secondly, my lords, field is covered by, my lords, the rules. It says, my lords, period of study. My lords, without defining, my lords, period of study, my lords, nothing is there in the rules also. My lords, it was not open for, my lords, for the state to come out with, my lord, this circular instruction. My lord, insofar as this, my lords, I have also relied upon a decision of this, the Honorable Supreme Court, my lord, which I have, my lords, filed along with the synopsis, my lords. Specific contention is, my lords, when the field is covered by rules, no circular instructions could have been issued. My lords, I have filed, my lords, memo for list of authorities. My lords. Your lords may kindly have a look at, my lords, 2007 15 SCC 129, my lords, which is
We'll see, that is
Yes, my lord. Yes, my lord.
non-proposition, that rule can't be amended by.
a circular instruction.
But the administrative instruction can supplement the rule.
Yes, my lord. That is always there.
What is the nature of this? Now, this, go to page 59, 60.
60, yes,
that
my
is
lords.
rule.
Please.
So you passed out eight exam,
My lords, my submission is that, my lord, the rules,
period of between 8 and
yes, my lords, the certificate, my lords, if I go back to, my lords, which is at, my lords, annexure D2, my lords.
no, you studied in which year?
My lords, 2023, I completed PUC, my lords, 2018, my lords, I joined, my lords, 8th standard.
And completed 12th standard in 23.
Yes, my lords.
So how this page R3 will come again?
Yes, my lords, I would, my lords, my lords, the rules would say is that, my lords, period of study. My respect
No,
for
how does this 23rd June 23 circular is adverse to you?
my lords, what, if you lords kindly see the certificate, what is issued, my lords, annexure D to page number 27. The event was, my lords, held between 1st to 10th April 2018.
Between?
1st of April to 10th of April 2018.
18.
They say, my lords, it is before the cutoff date, that is 1/6/2018. As such, we will not take that into consideration. That is one, my lords, argument they have.
But you are falling within between 1/6.
Please.
Not the crux of the matter is only that, my lord. The crux of the matter is only that, my lord. They don't fall in the cutoff dates. My lord, they fall short by about 2 months. And this circular, my lord, is only a clarification issued as the cutoff date, as that is the beginning of the year for an academic year, my lord. 1st June is the beginning of an academic year. And we have taken 5 years prior. So it is 31 May, 5 years back. Hence, they've participated in a tournament. It is a recognized tournament. There is no doubt about it, my lord, but that is not within the cutoff period. And the rest of the tournaments, what she has participated in, that is not considered to be eligible. That even they have no dispute about it.
My submission is, my lords, annexure R2 is not issued as a clarification, my lords, to the rules. The rule, my lords, the circular, if it is seen, there is no mention of the rules, my lords, at all. It's just how we are doing it. If at all it is said, my lords, it prescribes a period of study, so we classify this as between from this date to this date, my lords, I can understand. There is nothing in this circular, my lords. In fact, my lord,
File your counter.
I have filed my counter.
Lord, this,
We also.
Pleadings are coming.
I want to file a memo on 21/8/2000.
in fact, my lord, the state is on record, my lords.
She has been classified as P5. On that basis, she selected a seat, joined the
So your
institution.
rule says that all certificates which are obtained from the
Between-
commencement of study in eighth
Eighth.
till conclusion of study in 12th are liable to be considered.
Yes, that is the block
Now
period.
you are carving out a period which may exclude somebody like petitioner. Today you are studying somewhere?
My lords, I had to, my lords, join the, my lords, payment quota. My lords, my submission is that, my lords, if, my lords, I had no other option, my lords, because this petition was pending, they are not filing the objections. It is filed only now. In August 2014, my lord, the state comes with this objection on 19/8/2014. My lords, it is, my lords, my submission is, my lord, the seat can be adjusted, my lords, with the respondents or, my lords, this year, my lords, in the
That seat will
counseling.
go waste.
Which we are relying on, which you are relying on some judgment.
Yes, my lords, your lords, my lords, on the other day, I filed, my lords, list of authorities, my lords.
You have filed it.
Yes, my lords. In the court, my lords, I.
You participated in chess. Yes.
Please, my lord.
Which game you participated? Chess.
Yes, yes.
Yes, my lords. At page number 3, my lords, I have laid upon, my lords, the order passed by your lordships in the other matter.
You were admitted in the very year on payment sheet.
On pay, my lords, I have taken a payment sheet. My lord, as such, my lords, my submission, my lords, placing reliance on, my lords,
What fees you did pay
please, my lord,
for your admitted payment sheet?
payment sheet.
What is the fees? What are the?
My lords, about, it comes to, my lords, about 20 lakhs and odd.
20 lakh.
My lords, if I,
Here, what is the fee?
it will be around, my lords, I understand about 2 lakhs or. My lord, I'll have two chances, my lord, two choices, my lords, if I get P1. One, I can have, my lord, choice of the college. Number two, my lords, the fees will be less. It will be a government seat, my lords.
You would have got different college also.
Yes, my lord, it was possible for me.
And your lordship's judgment, my lord, there, my lord, the state found him eligible under P5. That's the reason my lordships have.
So you people are appearing, both of you?
For respondent number 13, appeal for respondent.
13.
They were selected candidates at that point.
Selected. So heard learned advocate, Mr. So-and-so for the petitioner. Learned additional government advocate, Mr. Sudhir Hegde for respondent state and authorities. Learned advocate, Mr. N.K. Ramesh for respondent number so-and-so Karnataka examination authority. Learned advocate, Mr.
I'm for respondent 7 to 9, 11, 12.
So-and-so for, and you are for?
Respondent number 13, my lord.
13.
13.
So-and-so 7 to 9 and 11.
7 to 9, 11, 12. 10 is not appearing.
9, 11, 12. And learned advocate Miss so-and-so respondent 13. At length. Learned counsels for the party stated that they argued the petition finally. All are represented, all testimony.
Yes.
And that the pleadings are complete. They do not want to add or supplement any pleadings, any supplement any further the pleadings. Resort for judgment.
Chess Federation of India not represented by.
Chess Federation of India is not been represented.
Who?
Chess Federation of India, my lord, those served. They are, my lords, they are not.
Chess Federation
Yes,
of
sir.
India.
So as for last, who is that number?
Respondent number
5. 6, sir. 6.
Number 6. Respondent number 6.
All India Chess Federation.
Number 6 goes out, has not chosen to act.
And respondent number 10 also, private respondent not appeared.
Both
10 respond.
5 and 10 both.
Yes, my lords,
No, 5 and 10.
my lords,
So result.
with leave, my lords, I'll make one submission. My lords, I'm required to, my lords, pay the fees, my lords, for the second year, my lords. I have cleared, my lord, the examination, my lords, in first class. Lords, my lords, consider it, my lords, pronouncing the order, my lords, at an early date, so that, my lords, it will help me, my lords.
It is our duty, we are alive to it.
My lords, it's only a request from my side, my lord, so that
Such a request is not in a good terms.
I'm sorry, I'm extremely sorry
Alive
about.
to our duty.
Yes, my lords.
Such
I'm
a
extremely
request-
sorry about it, my lords. It was my.
Any doubt about that course of action, you go before another court.
No, it
will
is
not
not.
take
No,
up.
no. What I tried to say, one lords,
So in
was
Gujarat, I never used to enter in such a request.
I'm extremely.
You can't presume that we are delaying it.
No. What I tried to say is, my lords,
We are alive to subject matter,
I understand.
alive to the urgency,
I understand.
alive to your rights, or we are alive to their rights.
I'm sorry, my lords. I'm
The
obliged.
request henceforth, any advocate makes will not take up the
My
matter.
lords, the only I. My
Out of
lords, I tried-
propriety on your part, and it is not acceptable to us at all, Mr. Counsel.
my lords, I'm extremely
Please
sorry. my
take
lords.
the word, such a requests are not to be made.
I'm extremely sorry, my lords.
Pension is not permitted.
I'm extremely sorry,
Maintain
my
the
lords.
decorum of the court. If you want to conduct the court before this court and conduct the court in accordance with the stream of the matters, you do it, otherwise you go before another court. We are not enamored to take any matter,
My lords, I'm
not
extremely
before
sorry.
this court then.
No, I'm extremely sorry, my lords, about that.
Don't mention such a.
In
such
fact, my lords, a request was made, my lords, from.
No, sir.
I am sorry, my lords. My lords, my lords, I have nothing more to say.
If you don't know the decorum and the propriety of the court, you must learn it,
I'm sorry, my lords.
counsel.
I am sorry. My lords.
We are devoting time like anything, you are making
My
such
lords,
request.
my lords, I'm sorry, my lords. It's only, my lords, for the reason, my lords, that they made the request, my lords, today, my lords.
Next matter.
I'm sorry.
Nothing more. Yes, Mr.
Basically. But that also is an asset.
Correct.
Therefore, we must take note of that. We do not come to a conclusion. In that case, this is, as an officer of the court, I am saying, because otherwise I would say that taking that seat this year and that having a vote, that will be the normal. But if this court comes to a conclusion.
We are not enamored to any advice. We are aware of it. No, next matter. You argue, don't advise the court. Yes. We are aware of everything. We have concluded the hearing. Any advices and instructions are not, we are not soliciting. We laid down the law. If we are not right, you can go ahead.
It is not a this is a submission as an officer.
What is this? This lawyer makes such request pronounced early. Other lawyer makes a suggestion. We are not accepting any suggestions. We know what to lay down and what not to lay down. Yes. Mr. Counsel, we are not here in any advisory jurisdiction.
We are not. My lords are not. Here, the sentence of a submission, as an officer of the court, if you are that, if that is the case, one possible remedy would be if this court wishes to pass that order. In case it comes to a conclusion, it would be that the state government, because in our jurisprudence, damages are not developed to that extent. I would request the court, when the Lord ask the question, what would be the extent of the fee? What could be done? One seat from the state government quota can then be transferred to the, so that seat will remain intact. And one seat here will get transferred to the other, so that the fee issue gets resolved, but not a wastage of a seat. That's the only submission.
We'll consider everything. Yes.
This is number 3. Lem Chidanandaya.
Appear for the petitioner and the matter.
Yes, madam.
Lordship's copy is served to me today, Your Lordship. Some time may be granted. Respondent number 2 has filed.
Learned advocate, Mr. So and Miss So and so petitioner, 6 times, stating that the copy of the affidavit in reply is served.
Statement of objection served by the respondent number 2.
Affidavit in reply comes statement of it. Stand over to 25th,
10 days time to be granted.
10 days. It can go after vacation.
Yes, Your Lordship.
It can go after vacation. Only 16th of October, as requested by her. As requested by her.
This is number 4.
Yes, for.
Number
Pita
4, I
Damodara.
appear for the petitioner, my lords. Last time the respondent number 2 had to get a direction because I produced, this is a matter pertaining to sports quota, my lords. I produced 2 certificates.
What happened?
They had to get an instruction.
Acceptable. It is
The last
acceptable.
occasion, my lords had directed the youth affairs department to forward it. We have forwarded to the KEM for consideration.
Lordship, I have this tomorrow, day after.
Plus orally they have informed us that they will be, we will be considered to round 2.
Then
Orally they have considered, my
Round
lords,
two is
but
definitely considered.
tomorrow.
Round 2 is not at all. Lordship, I have it on Friday or tomorrow. I will,
tomorrow,
Or 19.
19.
19.
that's 19th will be too
Tomorrow.
late because
Right.
Tomorrow.
only, this is orally they have informed us only in.
Mr.
they have-
Ramesh will try to.
Please,
I'll try.
please,
Or in fact, very.
grateful.
This is number 5. For petitioner. This matter, my lord, this matter pertaining to medical seat, my lord. My lord, this matter pertaining to medical seat, my lord. My lord, the petitioner passed the second PUC examination on distinction, my lord. My lord, he secured the marks, my lord, 559, my lord, out of 600, my lord. Thereafter, my lord, he returned the NEET examination, my lord. In the NEET examination, my lord, he secured the 560 marks, my lord, and also ranking, my lord, 1,24,657, my lord. My lord, when he submitted the application before the competent authority, my lord, he mentioned his caste, my lord, as a OBC 3B, my lord. My lord, but in the verification slip, my lord, wrongly mentioned the caste of the petitioner, my lord, is a GM category, and income shown the income as a 0, my lord. My lord, it is adversely affected the candidature of the petitioner, my lord. For that reason, my lord, the petitioner has submitted a representation before the second respondent, my lord, on 15/8/2024, my lord, for correction of the caste, my lord. But my lord, till this date, they have not taken steps, my lord. My lord, I produced my caste certificate, my lord, annexure F, my lord. Lord, verification slip, my lord, annexure C, page number 15, my lord.
It is too late, my lord. And in the application itself, he has not claimed OBC. He has claimed only as religious minority. OBC he has mentioned as GM. Yes, my lord, last. Yes.
This is one manifestation. But we have some changes that have happened. Regularization. This is the has reached.
Now, first round counseling is over. Two weeks.
Number 6, VV Siddaramaiah.
Preparing for petitioner. My lord, I will not press the memo. We have the IA number 1/2024. Memo may be dismissed as not pressed. IA number 2 is only with respect to correction of the academic year 2000.
This can wait.
Memo may kindly be dismissed as not, memo may kindly be dismissed as not pressed. I have filed a memo for consideration of interim prayer that may be dismissed as I will not press that memo. I have filed separate application. My lord, I have filed a memo. I am withdrawing memo. And IA number 2 is for correction of the writ petition that may kindly be allowed, my lord. There is office objection on memo. Subsequently, I have filed IA 1/2024. The office objection is I have to file an IA. I have filed IA in view of the same memo does not survive. And IA number 2, my lord, is with respect to correction of the academic year as 2024-25 in page number 11 of the petition. In IA number 2/2024. One amendment of the writ petition. That one IA is for consideration of interim prayer, another IA is for amendment of the writ petition. So only correction of the academic year as 2024-25 instead of academic year 2023-24. Please, ma'am. Amendment.
So IA 4 of IA 4.
amendment.
I1, 1 of 24, heard learned counsels for the respective parties. The present is in application under order 6/17 of the Code of Civil Procedures 1908, whereby the applicant petitioner seeks to amend the memorandum of original petition by praying thus. Bracketed portion on page 46. Full stop. The amendment is formal in nature and the petitioner applicant wants to correct the academic year as 2024-25 in place of 2023-24. Accordingly, amendment is granted as prayed for. The interim application is allowed.
Yes. My lord, filing of amended petition may kindly be dispensed. Only small corrections.
Looking to the smallness of the amendment, filing of the amended petition is dispensed.
I may be permitted to carry out amendment right now, my lord.
Pardon?
I may be permitted to carry out amendment right now. Yes, please.
Yes.
This is number 7. So Prasanna Deshpande.
Petitioner's counsel. The translated copies I'm told already, the office objection. But there was office objection regarding translated copies. It's ready. But this is where a case where the petitioners, my lords, are claiming reservation being going to Jain community. The issue raised is that they were not given an opportunity, though Jain community is now one of the 6 minority communities, my lords. That there was no opportunity to claim that reservation in the KA portal. That's the, and we had approached and we had, this honorable court had directed a representation to be considered. Government has passed an order at annexure G page 37, the translated copy which you have asked, saying that there is no opportunity to grant reservation. The impugned order is at page, along with the memo of translated copy we have produced. Then seems to have been, my lord, set out at para 6 of the petition. Grievance. That's what they have to consider and come back. Because the law department has opined something else which the government order records, that we are entitled, if we are not given, it amounts to a constitutional violation. But the government order says, as of now, we cannot.
Lord, I need some instructions in this matter, my lord. Request for a week's time, my lord. I need some instructions in this matter.
Notice, my lord, today. We'll file our counters. This requires, my lord, a statement of objection.
So Christians and Muslims are given.
Yes, but because
No, so for giving them any separate notification is received?
yes. No separate notification as such, but seats are earmarked for those minorities in those minority colleges. For Jains, my lord, there is no Jain institution at all in the state of Karnataka.
So that must be a separate notification. Saying that the seats for Christian or Muslims are
Yes, yes.
earmarked for the minority institution.
Yes, yes. In the seat matrix itself, it comes. Government gives a seat matrix in that itself. it
So
comes.
these minority status will be available only in minority institutions?
Only in minority institutions and also under general merit category in government seats. Government colleges, general merit or SC, ST or OBCs.
So the Jain will be in reserved category?
Yes, he claims only he comes under OBC. OBC they have not claimed at all. They have claimed only
Minority.
religious minority.
Religious minority.
That's the issue. But I will
So
address
there is
this.
no provision for religious minority in general reserve?
Yes, no.
Anywhere, never?
Anywhere, no.
nowhere.
That's a private seat. All seats are going to them only.
But where there are minority institutions, the
Yes,
provision is.
they go as a matter of right.
Minority institution.
Therefore, we are asking it, that is done under which, by which instrument? By notification?
Lord, that is by a consensual
A
agreement.
consensual agreement.
Consensual
Consensual
agreement.
agreement under section 4A of the.
That's what they
Act.
do is
With
under
minority institution?
Yes, sir.
private
Act.
unaided, my lords, minority institution by way of a consensual agreement. If it is recognized as a minority, for that particular minority, 66% of what seats they get, they should allot it to that minority.
That narrative.
That's the agreement they have done. So if there is no other minority college, we will not be, though I am recognized, my lords, I am not getting any benefit. Now what they say is
That consensual agreement is minority institution.
with the institute, minority.
A group of institutions, rather.
It only says 66% of them, my lord, they are entitled to 55% of seats. They surrender 45% to the common entrance. Sir.
I will reply.
Yes, we'll reply.
If the counseling gets, if they can try by Friday, my lords, if they get some information, that's all. I can't ask anything more.
It's difficult that you will get relief this year.
No, I understand. It's a issue, my lords, sir. I
The
understand.
case of final hearing. And
It becomes only academic if the student.
will set the tone for others, if you succeed at all. We do not. Not, rule will issue rule returnable.
Pardon me, my lord.
Rule returnable.
Let's,
Rule returnable. No, notice.
OBC, I can't come.
Heard learned senior advocate Mr. Panindra with learned advocate so for the petitioner, notice returnable on. When you will file?
But a week's time, I'll
24th of September.
please.
Counseling.
Learned
Counseling
advocate,
hour.
Mr. Learned additional government advocate, Mr. Vijay Vegare,
For R1
and learned advocate, Mr. Ramesh. Excess notice on behalf of respondent.
1 and 2, my lords.
As
Comment.
Respondent Karnataka again. They stated that they will file their
ಇನ್ನು time ಇದೆ
statement of
ಅಂತೀವಿ.
objection come reply before the next week.
24th, your lordship. 20.
List one, so contempt matter, seal number one. Shwishwanathan.
I appear for the complainant, my lords. My lords, this is the second contempt petition, my lords, filed by the complainant, my lords. Earlier, a contempt petition was filed, my lords. The accused had violated the writ petition order, my lords, the interim order, my lords, and they had constructed a road on my land, my lords. And in this contempt petition, my lords, they have constructed a compound wall in and around my land, my lords. And there is a status quo order by this honorable court in a writ appeal, my lords.
What happened to writ appeal?
Writ appeal is still pending, my lords.
Consider. Page 19 is the order.
My lords?
Page 19 is the order you want to comply with.
Yes, my lords, yes, please, my
It
lords.
is interim order, we are not entertained. Having heard learned advocate Mr. So and so, and having noticed the order, having noticed the nature of the order dated 4th July 23, passed in writ appeal number 248/23, which is an interim order. And further considering the aspect that the writ appeal is pending before the competent bench, comma, since it could not be said that rights of the parties are have finally crystallized at this stage. The court is not inclined to entertain the present contempt petition in respect of the said interim order dated 4 July 23. Accordingly, the petition is not entertained. The petitioner is permitted to work out his rights and remedies before the
My lords, one more submission, my lords.
appellate bench in the writ appeal by raising all the available contentions of law and facts.
My lords, the first contempt petition, my lords, they had violated the writ petition order and it was dropped on the.
It will be also open to the petitioner to get the writ petition listed at an appropriate earlier date
Writ appeal, my
by
lords.
following the writ appeal. Yes.
So number 2,
My lord, I appear for complainant in this case, my lord. My lord, the petitioner was, my lord, in cultivation of the 2 hectares of land, my lord.
The
for
order is of
40.
the order is of 2022.
Yes,
So
my
how
lord.
do you,
There's,
how do you come out of section 10 of the contempt of courts?
my lord, my lord, I gave many representations to the
No, that
petitioner,
will-
my lord. Your last may kindly see, my lord.
Contempt of courts.
My lord, your last may
Sorry.
kindly see the. My lord, your last may kindly see the representations given by my lord,
That
the petitioner.
representation will not extend the limitation period. Yes.
But my lord, the committee was not formed at all, my lord, even though I gave many
Committee was not
representations.
formed. Then
Committee
it's
was
a
not
different thing. Reconstruction committee, when it was formed?
Well, it is not formed at all, my lord. Till now, it is not formed. Therefore, my lord, I gave a representation to the
Committee was not
DC.
formed
It is
for 2 years.
formed and we have considered their application also. In fact, I filed my compliance affidavit.
Compliance report is filed.
Please.
Where is that? Page
Uh,
7.
Lords, page 3 of the affidavit, my lords.
I have been not served the copy of the affidavit, my lord. My lord, in fact, my lord, one endorsement is issued by the Tahsildar, my lord, on 4/9/2024.
No,
After
where is
filing of,
My lords.
Where is the committee's this?
Well, it's here, the only direction was to place it before the committee and we placed it before the committee. And an endorsement based on the proceedings of the committee, an endorsement has been issued by the Tahsildar minutes.
my lord, that endorsement is, my lord, issued to the petitioner, my lord. I am having this endorsement dated 4/9/2024. My lord, for the astonishingly, my lord, the committee is not at all formed. And the committee members, my lord, informed this petitioner that without referring to the committee, my lord, this endorsement is issued by the Tahsildar. Even though he is cultivating this land for 40 years, and many other petitioners are sailing along with this petitioner, my lord.
Sorry, following heard learned advocate is so and so for the petitioner who appeared and raised submissions, who appeared online and raised their submissions on behalf of the complainant. As also learned additional government advocate, Ms. Pramodini Kishan, for respondent state. Following are the directions of learned single judge, which were passed in order dated 16th February 22 at disposing of the petition
My lord, on
to be
submission, my
subject
lord.
matter, to become subject matter of, to be made subject matter of the contempt jurisdiction of this court. Page 11, 12, paragraph 3, 4. Ordered accordingly.
My lord, the direction is to form the committee, but committee is not at all formed. The committee members themselves stated committee is not formed, and this Tahsildar has not approached the committee, my lord. And the Tahsildar who I am made party, my lord, Nisargapriya is not at all there,
Thus,
my lord.
the direction was issued to respond for Tahsildar to place the application in form number 53 of the petitioner before the committee for regularization of unauthorized occupation. And the decision was to be taken after consideration of the subject matter by the committee. Paragraph. Though the order was passed on 16th February, paragraph 2022, implementation could not be obtained
Yeah.
for the reason, as stated by learned additional government advocate, that the committee for regularization of unauthorized occupation was not constituted for a long time and was not functional. Full stop. However, it was stated that the committee has now been constituted. Paragraph. In response to the notice issued by this court, paragraph. Affidavit is filed by compliance. Affidavit is filed by respondent, Tahsildar, in which it is stated that pursuant to the directions of this court, the documents were verified and the application of the complainant was placed before the committee for regularization of unauthorized construction. Rules of the committee in its proceedings held on 3/9/24 considered the application and rejected the same under Rule 97 of the Karnataka Land Revenue Rules 1966. Full stop. An endorsement was issued to the complainant applicant on 3/9/24, intimating the said decision.
My lord, to your lordship's kind consideration, my lord, the committee is not at all formed, my lord. Committee is not at all formed. This is only, my lord, endorsement issued by the Tahsildar without consulting the committee. That is, the committee members have informed the petitioner, my lord. This is a
Regarding
false.
the-
When the contempt is filed, my
It
lord,
is formed and considered, madam. What are you arguing?
my lord, let them produce the proceedings of the committee, my lord. Without there being any proceedings of the committee, this endorsement is given by a Tahsildar who is on deputation. He has no knowledge of the proceedings, my lord, earlier proceedings. There is no committee at all. To avoid, my lord, the clutches of the contempt petition, my lord, in a hurry, without inspection, without consulting the committee, my lord, this Tahsildar who is on deputation has issued this
It is stated
endorsement.
in the compliance affidavit that the proceedings of the committee were held on 3/9/24. The committee in its proceedings recorded that the land reserved for the cattle, as per Rule 97 of the aforesaid rules, is insufficient in the village concerned. The land is required to be mandatorily reserved for the cattle as per the rules.
Let them produce the proceedings of the committee, my lord.
The application of the complainant could be placed before the committee when the sitting of the committee took place, it was stated. Paragraph. Along with the compliance affidavit, endorsement dated 4/9/24 is also produced, recording the proceedings before the committee and that the application and stating that the application of the petitioner complainant came to be dismissed. Paragraph. Learned advocate for the petitioner sought to harp that there is no constitution of committee. Full stop.
Yes, my lord.
The submission has no legs to stand, inasmuch as it was categorically stated by learned additional government advocate that the committee has been now constituted and it considered the application of the petitioner through Tahsildar. Full stop. The compliance affidavit also mentions about the proceedings dated 3/9/24 conducted by the reconstruction committee and the decision taken as per the endorsement. Full stop. As the directions are paragraph complied with, directions of learner single are complied with, and the endorsement is issued. Nothing survives any further in this contempt proceedings. They are disposed of as dismissed, not surviving. Full stop. If any grievance subsists for the petitioner in respect of the endorsement passed, it is always open to the petitioner to institute appropriate challenge independently to the said endorsement, in respect of it, this court does not express any opinion on merits.
Please, my lord.
Number 3, Mr. Ravindra Rao K.
Appearing for the complainant in this case, your lordship.
Here there's 14 years delay, my lord, from the order passed.
Your Lordship, the cause of action has arisen in this case last month.
Where are the
Or-
directions?
Your Lordship, Annexure A, page number 10, Your Lordship.
Page number 10 years, but where are the directions?
Paragraph number 1 and 4, Your Lordship. In this case, the accused had also given an undertaking that they will retain the land survey number 190 as the burial ground. An order to that effect was also passed, which is found at paragraph number 4. May I read the order, Your Lordship?
Read it. Read it.
Paragraph 1, the instant writ petition has been filed as a cause
So
of
you
pub-
read the directions only.
Your Lordship.
Which are the directions you want to
The directive
implement?
is to retain that land as a burial ground.
Very
That
good.
was
Read it.
paragraph number 4, Your Lordship.
Read
Ink page number 14.
Read it.
In view of
And
the
no-
above, we find no justification for interfering in the action of respondents on the basis of the cause raised by the petitioners, except to the effect that the respondent shall be bound by the undertaking given to this court to the effect that survey number 190 shall continue to be used as a graveyard for all intents and purposes.
So what is happening now?
In survey number 190, they are now constructing an overhead tank. That
Notice
is why we
returnable.
have,
Notice returnable after
Your
holidays.
Lordship, my only request is let them not continue with the construction, Your Lordship.
That
They're
can't be
already
done in
construct-
contempt matter.
That's, it is after 14 years of this order.
14th October.
That is because they started the construction last month. That is why we have got the cause of action to file the contempt.
Stoppage of construction cannot be ordered in contempt petition.
No, if an undertaking to that effect was given by the government.
Therefore, we are issuing notice.
Yes, if an undertaking was, because we have served the government, they are aware of the order of the High Court. We had given them representation
If you
also.
succeed, then we'll make them to demolish the construction.
Number 4, Mr. Anup Parnali.
Notice returnable on 14th October.
Hearing for the complainant must.
You are number 4?
Serial.
Yes, notice.
Number 5, Vasant Kumar HT,
Notice returnable.
complaint.
Same date.
So PL matter, number 6, Mr. Ravi Kumar.
Yes. Madam. Well, Annexure A, RTC. The petitioner is seeking direction against the respondent number 1 to 4. Remove the illegal construction on the made by the respondent number 5 on the government land. Madam. Annexure A, madam, page number 24, RTC, madam. Translated copy in page number 25 in column number 9. It is a government, it shows government land, madam. Then, my lord, in page number 30, my lord, photographs I have produced, my lord.
Photographs. Let us see photo.
Page number 30, my lord.
Page number 30.
The respondent number 5 has started the construction. In this regard, my lord, I have given the representation on 12/9/2023. Then, my lord, survey has been conducted by the revenue inspector. And in the report, my lord, it is clearly stated, it is the government land, it is constructed and given the instruction to the respondent number 5 to stop the construction. Then, my lord, further, my lord,
What is the construction? Some hut. This photograph.
that is
Number 5 is doing. Who is number 5?
in the report, my lord, page number 30, annexure H, my lord. It is the report of the revenue inspector. The respondent number 5 has intended to construct auditorium.
Where is the report?
Report, my lord. Page number 38.
Page 38.
Yes, my lord. Translated copy in page number 40.
Mahaganpati Trust is doing.
Yes, my lord. But my lord, without obtaining.
So you come in a wrong time with this petition.
That
Notice. Notice returnable on after this will go 21st October. Learned additional government advocate Srimati Nilo Parakar. Accept.
The green bench matter, still number 7, the senior part.
Petitioner in this matter. Lots of petitioners.
Who are you?
I'm the grantee of the land in question, which is subjected to allotment for removal of sand in favor of.
You are granting
Yes, my lords.
and somebody is constructing.
No, the land has been given by the mines department, respondent number 2, in favor of respondent number 7, who's constructing a national highway for removal of sand. My land has been allotted to respondent number 7 for removal of sand.
This one number 7.
Yes, my lords.
It is a private company.
It's a private company.
Which is that land?
Not sir. Land in question was granted in my favor way back in the
Survey number 141.
141 to an extent of 10 acres.
So by some order it is granted to number.
Yes, my lords.
Where is
Annexure
that-
A.
Where is that order?
Annexure A.
Annexure?
Annexure A, my lords.
First of all, where is your order of grant?
My order of grant is subsequent, man. Annexure B onwards.
Yes, where is that annexure B?
At page number 34, my lords. Translated version is at page 36.
36.
36, 36. This is a cultivation certificate, Hangami cultivation, my lords, issued in the year 1942. Subsequently, my grant was regularized and I was issued Saguli chit at Annexure C, page number 38. I have produced certified copy.
So 1942.
1942 and 1946 is my Sagul chit.
It continues with you.
Yes, my lords.
Where is the last order?
My lords, the last order is the revenue entries were not mutated in my name. I approached this honorable court.
Where is the permission of the kind at page 36?
My lords, the finding of page 36 is reflected under an order passed by the assistant Tahsildar, which is at.
No,
Annex-
what is there to show that page 36 rights continue with you today? Because this page 36 is of the year 1942.
Yes, my lords. My lords, I have paid tax. I have been paying taxes to the state. And by oversight, my name was not reflected in the RTC, my lords. Otherwise, I have produced merger which has been conducted by the revenue authorities in the year 2017 to reflect that I am in possession. The proceedings of the revenue authorities reflect that I am in possession of the land which was granted in the year 1940.
Lord Learned Advocate, Mr. So and so, so and
My
so.
lords,
There is nothing absolutely.
my lords, my lords, may I just take this honorable's
Learned
reference,
additional
court reference to
dominant.
Annexure P, my lords. Annexure P, my lords. An order passed by the Tahsildar at page number 43. 93, my lords. Annexure P at page number 93. This is an order passed by the Tahsildar in pursuance of a direction by this honorable court. Single judge bench. Under this order,
Page?
page 93, my lords, Annexure P, translated version commences from page 98.
98, yes.
Yes, ma'am. Kindly at page 104, my lords, sir.
Hmm.
In the operative portion of the order. At 108, my lord, 4, my lords, I read. Sulibele Hobli so and so. To be Kata cultivated. A memorandum has been issued to Abilekaya branch to submit a report on reality. Accordingly, the original sanction fine land is not available. Cultivation distribution certificate are issued as certificates are available. And the cultivation distribution register.
Your prayer for grant of what? Cultivation certificate is rejected.
My lords, what the finding is by the Tahsildar is there is a grant file, issue register extract is there. It reflects the name of petitioner's father. However, now
Under this order, I come to know about the allotment made in favor of respondent number 7. Under this order, though the land has been granted in favor of petitioner's father, there is a finding to that effect in this order passed by the Tahsildar. They say that now that in the year 2022, we have made an intention proposal for sanction of land, it has to be leveled. Thereby, we have given it to Dilip Buildcon, respondent number 7. This is the contention taken by the Tahsildar while passing Annexure P, my lords. He does not deny my grant. He does not reject my grant. There is no dispute with regard to the grant. He admits, yes, Saguli issue register is there. And my father's name is reflected to an extent of 10 acres. However, that land we have proposed to level, clear the sand and gravel. And land has been granted to respondent number 7. Allotted for removal of sand. My lords, I have been in cultivation since more than 80 years, my lords. Now they intend to get sand for the private company. They find my land feasible and they have allotted it. Annexure P speaks of grant in my favor, my father's favor. It admits virtually, however, while concluding the said order, the Tahsildar notes that since the land has been proposed for allotment and sand has to be removed, it has been given to Mines and Geology Department.
Heard learned advocate Mr. So-and-so for the petitioner and learned additional government advocate Srimati Nilofer Akbar, who appears upon service of copy of the petition in advance on behalf of the respondent state and its authorities. By filing this petition in Article 226 of the Constitution, the petitioner is prayed to set aside order dated 11/1/23 passed by respondent number 2, the Deputy Director, Department of Mines and Geology. Devanhalli Taluka, Bengaluru Rural District. Dated 11/1/23. Insofar as it permits not in respect of which is in respect of survey number 141, admeasuring 6 acres land situated at Begur, Begur village, Sulibele, Sulibele, Obli, Hoskote, HOSKOT, Taluka, Bengaluru, Rural District. Full stop. By the said order dated 11/1/23, certain rights are granted for excavation of sand in favor of respondent number 7, Messrs. Dilip Buildcon Private Limited. The petitioner is that the land in question was granted to the father of the petitioner, one Yemegalla, YWMEGL, TYAVAPPA, Dwayappa, on temporary basis for a period of 3 years, which was by order dated 26/5/1942. Paragraph. Having considered the readings, the record of the petition and the submissions made by both the sides, there are 2 good reasons for not entertaining the present petition. Firstly, the petitioner is not able to show that he has any subsisting right in respect of land in question. The order which is claimed to have been passed, giving the land to the petitioner, was of the year 1942, which was valid for 3 years. Full stop. It is petitioner's own case that thereafter petitioner had made representation before respondent authority to mutate the khata in respect to the said land in the revenue records in our favor. However, the same was not done and the representation remained pending. The petitioner had an occasion to file writ petition number 8807 of 2021 in which also the only relief granted to the petitioner was to direct the respondent to consider the representation. Full stop. While on one hand, the petitioner has not been able to make out any right in respect to the land in question to seek relief, there is a weightier reason why this petition deserves a ready dismissal. Full stop. Impugned order dated 11/1/23 is an authorization letter whereby this one number 7 is permitted to remove and use certain amount of soil for road works as per Rule 3 capital A of the Karnataka Sub-Mineral Concession Rules 1994 as amended in the year 2016 and 2020. Full stop. This permission is valid as per the express stipulation in the authorization letter for a period of 6 months from the date of the order. Full stop. It is within 6 months that the respondent number 7 was, it is for the period of 6 months that respondent number 7 was granted permission to obtain the soil and transport the sub-mineral for use of national highway work. Full stop. The order was, the authorization letter was dated 11/1/23. Full stop. The 6 months over, got over on 11/7/23. Full stop. Neither the petitioner has a right to institute the petition, nor any cause of action arises for the petitioner. The petition is thoroughly misconceived and amounts to abuse of process of law. Therefore, it is dismissed with cost of rupees.
My lords, on submission. My lords, I am not a hangami cultivator. I am an allot granted the land while giving dictation. This court was
Cost,
pleased.
what cost?
My lords, I have been granted land in the year 1946.
What cost?
I produced Sagul.
Cost of
My
rupees.
lords, my land has been encroached. My lords.
Cost of rupees 5,000. Your period is over before 6 months and you are coming for
My lords, they have not yet initiated the works. My lords, this is my contention.
5,000 to be paid to the Karnataka High Court Legal Service Authority within 15 days.
My lords, while recording my submission, this honorable court dictated for 3 years. Subsequently, Saguli chit has been issued and I produced. No, no.
Forget your right.
That's
The
fine.
permission was granted for 6 months only.
They have
It is
not
over
yet,
now.
They have not yet commenced.
You are
the-
coming after 6 months, not within that 6 months, but after 6 months. So nothing, there is no cause of action for you.
Much.
Yes. So
Number
delete
eight.
the,
Insofar as cost.
delete the cost parts, dismiss summarily. It could have been dismissed with cost, however, taking lenient view, cost is not imposed. Yes.
Much okay.
Number 8, Shivkumar.
Petitioner has challenged election A, my lord. Identical matter, my lord, is under challenge in WP number 15865 of 2024. It is scheduled to be held on 29/2024, my lord, wherein the state government has filed their objections and the petitioner, there, my lord, has to file their rejoinder. May kindly be tagged on with that, please. Identical writ petition, my lord. Their annexure A is identical annexure A is challenged in WP number 15865 of 2024. It is scheduled to be held on 29/2024. In this writ petition, my lord, the state government has already filed their objections. And my lord, the petitioner has been requested to file rejoinder for it. May kindly be tagged on with that. Please.
As per the request of learned every petitioner to be tagged with, without applying mind, I am doing. Rate appeal number so and so, rate petition so and so.
15865,
15850,
2024, please.
2024.
Please.
From accepting the statement of the learned counsel that both petitioners cognate.
Please, my lord.
Rather relying on the statement, not accepting, relying on the, yes. Yes.
Number 9. Janupanna Bhotalai.
For petitioner, seeking for a quashing of an auction notice, my lords. Lords will get it at the annexure A, my lords. My lords, what had transpired was I had a valid lease till 2012.
And the department had given me permission to stock the low-grade mineral in a particular place. Then, my lords, they have filed a criminal complaint against me that was also quashed by this honorable court. B report was also filed by the concerned police station. And now, my lords, they are seeking to auction those low-grade materials, my lords, which were permitted by themselves to be stocked. And my lords, I have produced the permits and everything, given them representations also. None of my representations were also considered.
No, no, 14. 14. Yeah. That is not the office of game.
So what is the problem?
My
What is
lord,
your
that-
right?
My lords, now these materials are the waste materials which were lying in the stockyard as per the permission of the DMG themselves. Now they are seeking to auction those materials, and if this auction happens, I will lose those materials.
Why they are auctioning?
My lords, by virtue of this Annexure A, they are auctioning.
Why? Not by virtue of. For what reason they are auctioning?
They are saying that these are seized material, these are their material, because the matter is pending before the criminal court, my lords. They had filed a criminal complaint before the jurisdictional court, my lords. That, my lords, will get it at page 116, my lords. And B report has been filed. They have filed a protest petition. And while the protest petition is pending adjudication, they sought to auction the materials, my lords.
Where is your representation?
My lords, my representation, there are two representation. One is on 28/8/24, page 23, my lords. Then, my lords, one more representation that we have given on 15/3/2024. None of these representations were considered. Another representation at page 158, my lords.
Hmm?
At page 158, another representation.
So they are saying that it is their material.
My lord, pursuant to the directions of the Honorable Supreme Court, my lord, dated 14th March 2024. My lord, the Central Empowered Committee has been directed to conduct a joint survey to categorize these minings, my lord. Now, the petitioner's mines haven't been categorized. My lord may take the internal page 4. My lord, while referring to the, my lord, the petition of Samaj Parivartana Samudaya, my lord, internal page 4 may be seen, my lord. Wide report dated 3/2/2012. That paragraph. My lord, may I read it, my lord? My lord gets it. Internal page 4, my lord.
CEC is more central.
By the report dated 3
Environment Committee.
Empowerment Committee.
recommended categorization of the mines into categories A, B, and C on the severity of encroachment by the mines and overburden dumps determined in terms of the percentage in relation to the total lease area. In such categorization, category A mining lease bare number stroke marginal illegality and category C mining lease stand in flagrant violation of laws. My lord may come to the next page, my lord, page 5 at the bottom, 7B1 category mining lease. My lord gets it, internal page 5, my lord, the last paragraph.
But how do we know that this is pursuant to the Supreme Court order?
My lord, I'm producing the Supreme Court order. My lord, the petitioner's mining is mentioned in internal page 5. My lord, the second paragraph. Yes, yes. Hind traders, my lord gets it, internal page 5. My lord, the sentence starts with 7B1 category mining leases.
Mrs. Hind.
Yes.
Where is that?
Hind traders at serial number 3.
Ah, Hind traders. So
My lords, I am not talking about the categorization of the mine. I am talking about the stocks which were taken
it
permission
is a
from the
factual
jail.
aspect. How can we decide whether it is your or your?
It is come.
My lord, if it
And
if
my
the-
lords, may kindly see the B report that has been filed.
This is Hind traders.
Traders, my
Yes.
lords. The Hind
Survey number 1, extent of in hectares 19.63 hectares, village Vitalapura, Sandur, Bellary.
My lord, they'll have to approach the Honorable Supreme Court. My lord, the auction will be conducted. My lord, and the amount will be appropriated towards the state exchequer. My lord, once they categorize the mine of the petitioners, my lord, depending on if it is a B category, then they are entitled for refund, which the government will have to refund. But if it is categorized as a C category, my lord, then they are not entitled for this amount. And the amount is 2.56 crores. If they want the, my lord, they don't want the auction.
But in your order at Annexure A, page 22, as my brother is rightly pointing out, the survey numbers are different. This is survey number 1.
My lord, that has
because
been,
this is, it is a stockyard.
thereafter it
These
has been
materials are
bifurcated
pertaining to
as
stockyard.
6B1 and 6B3, my lord. They'll have to approach the Honorable Supreme Court.
If bifurcated, you show something.
And then I'll get it, my lord, we have this tomorrow. Or at 2:30 we can show. My lord, 2:30, my lord, may I have it at 2:30. Because it is one board, so many hectares.
Writ appeal matter. Number 10. To
Yes.
Nataraja.
Here for the appellant, my lord. Appellant's father had purchased a land measuring 1 acre 6 guntas, the year 1963. Subsequently, his wife made an application to the third respondent for change of revenue entries in respect of this land in favor of her family. But the respondent 3 rejected the application. Subsequently, the appeal was also rejected and the review petition was also rejected. Against that, writ petition came to be filed and writ petition came to be rejected by this honorable court. The order is at page 8, single judge's order is at page, my lord. Page 8, my lord. And the order says, para 4 is the reasoning. It says there are two sale deeds. Actually, there are only one sale deed with respect to the appellant's father. Page 8, internal page 10 is the relevant portion of the single judge's order, my lord. Revenue entries should naturally follow the registered document. And the point involved is already covered by judgment of this honorable bench, my lords.
So you purchased the land by some.
Yes, my lord.
When?
My father of the appellants purchased in the year 1963. The document is Annexure D.
Then what happened?
Subsequently, in the year 2014, after the demise of the appellant's father, his wife approached the respondent number 3 for change of revenue entries. The application was rejected by Annexure C. Subsequently, appeal was filed. Appeal was also rejected, my lord. And the review petition also came to be rejected.
So you are claiming the
Change of revenue
entry
entries.
on the basis of, please answer without understanding, don't jump into arguments. You are claiming the mutation entry on the basis of the registered deed
Yes, my lord.
of which year?
1963.
By your father.
Yes, my lord. Yes, my lord.
And what is the claim of the other side?
Other side is claiming we have not executed the sale deed. And they have filed a criminal case against the mother of the appellants.
And what is the order passed by the you are challenging?
That is Annexure A, B, C in the writ petition, my lords. That's the Annexure C is the order passed by the Tahsildar, rejecting my application. Annexure C is page 37, and the translated copy is at page 38.
38, yes.
This is the endorsement given by the Tahsildar, where it says last.
It was a registered deed?
Yes, my lord, registered deed. I have produced the encumbrance certificates also.
So this civil suit is filed by whom?
Not civil suit, my lord. That is a PCR filed by the respondents.
What is PCR?
That is a private complaint. Subsequently, it is registered as a CC, criminal complaint.
By seller?
Yes, my lord. Sellers,
What is that
sellers legal heirs have filed a criminal complaint against the mother of the appellants herein. Mother has died. This now the PCR is converted into
legal heir of the petitioner has filed.
Yes, ma'am. Legal heirs of the seller who sold the property to the appellant's father. They have filed.
But the deed is registered deed.
Yes, my lord. CC is registered. Deed is registered. I have produced the EC also. Your lordship may kindly see page 53.
And who is this Ramappa?
Ramappa is the father of the appellants, my lord.
Father or,
yes,
or brother?
Father.
So who is this Mahadevan?
Mahadevamma is the mother of the appellants. She has died.
You purchased from mother?
No, my lord. Mahadevamma is another, that is different. Your lordship may kindly see the sale deed which is produced at page 53. Sorry, page page 47 is the translated copy of the sale deed. 47. It says in favor that this deed of immobile property of dry land is made and executed on this 30th day of September 1963 by us Sri Mahadevamma, daughter of Bode Sangappa, and my husband Mahadevappa, son of Subbappa, adopted son so and so in favor of Rudrappa, son of Devappa, belonging to Veerashaiva.
Rudrappa is your father?
Yes, my lord.
So what was your application for Tahsildar?
Tahsildar application I have not produced, my lord. Endorsement I have produced. which is at page 38, translated copy annexure C.
But you did not do anything for long years.
No, my lord, that. But under section 128 of the KLR Act, there is an exemption for reporting of any such transaction, my lord. Annexure B is the appeal filed.
The case heard, learned advocate Mr. So-and-so, so-and-so. The case of the petitioner is that the property in question was purchased by him, by his father, one Rudrappa, from Mahadev Vampa and Rudrappa are related.
Yes, no, my lord. They are different.
They're different.
The
Not
caste also-
related. Not related.
Not related. Caste is also different.
The case of the petitioner is that the land in question came to be purchased by his father, Sri Rudrappa, son of Devappa, from one Sri Mahadevamappa, daughter of Ode Soge, Sangappa, by a registered sale deed. Dated 1963.
Yes, my lord. 39/1960.
13/9/1963. On the basis of the registered sale deed, the petitioner approached Tahsildar seeking mutation of khata in his favor on the basis of the registered document. Full stop. By endorsement dated 12/7/16, the Tahsildar refused the request. One of the reasons recorded is that the proceedings in the nature of PCR number 255 of 2014 is filed by the heirs of the seller of the property, questioning the sale. The said order, when appealed against, was confirmed by the appellate authority. It is against the said orders that the present petition is filed. It is against the said order that the petition came to be filed, seeking the orders to, seeking the prayer to set aside the said orders. Paragraph. On a single judge. What is this 26/7/75?
That is the date of death of the appellant's father, my lord. That is wrongly depicted as the.
Learn a single judge.
It is
To
already
review that the
covered by
date was
judgment of
based
the
on two
lordships.
registered sale deeds dated 30/9/1963 and 26/7/1975. In that view, it relegated the parties to approach the competent civil court for redressal of grievance. Paragraph. In course of the assailment of paragraph, the order of learned single judge, learned advocate for the appellant pointed out that it is only one registered sale deed,
Yes, my lord. Yes, my lord. There
which
a-
is in picture. The said registered sale deed, as stated above, is in favor of the appellant petition. The other date mentioned to be 26/7/1975 of another registered sale deed is an error of transcription in the order. The said date is referable to the date of the father of the petition.
Yes.
Full stop. It is tried principle that mutation entry has to follow once there is a registered document. In this view, a prima facie case is made out. Notice returnable on 27th of September. Status quo shall be maintained with regard to the entry, revenue entry.
Yes.
In relation to subject matter land.
That.
Silver 11. Srikanth.
Regarding that
Senior
maintenance of
citizens.
senior citizens, my lord, it was heard for some time other day. Then my lord friend took time to.
We are ready.
This is regarding maintenance of senior citizens.
It was heard for some time, and then I brought to your lordship's notice that different views, my lord, of different high courts. Then my learned friend took time to file the synopsis. He has filed the synopsis. No, I'm ready, Mr. The facts of this minute, I have filed the synopsis also.
We'll take up on 24th.
24th, minutes, please.
Grateful.
Interim order to continue.
We'll require me for. Ready.
Interim order to continue. Interim order to continue, means.
Send or to. If there is no hurry, then let it go after holidays.
No, less.
24th interim order to continue till the next.
Number 12, the appeal by state.
Well,
My lord, I appear for the appellants in this matter. My lord,
You
this,
appear for the respondents.
my lord, this pertains to, my lord, the filling up of vacancies. My lord, there are more than 3,162 vacancies, my lord, and those have fallen vacant from 1/1/2021. My lord, on the last date of hearing, I had submitted to my lord that by order dated 7/8/2024, my lord, we had filled up vacancies till 30/12/2020. My lord, I pray for some more time, my lord, to get instructions from the government with regard to, my lord, the filling up of vacancies for the remaining over 3,162.
Notice delay of 47.
Very.
Notice returnable on. It will go after vacation.
Very.
22nd October.
Number 13.
Paper the selection. Lord, the order of the learned single judge is dated 25/3/2023. But my lord, in the month of March 2023, I had got
Notice delay, notice returnable on 23rd October.
So number 14.
My lord, I
Appeal
appear
by
for the
state.
appellant. My lord, there is a delay of 544 days, my lord.
Notice 23rd September, October. One 15 for.
Number 15. Appeal by state. 15.
15, my lord, I appear for the appellants.
notice.
But I appear for the respondent. But Election Commission had invited tenders for asking us to work for these elections, during elections, for providing food, etc. 2019 parliamentary election, 10 crores we spent. Deputy Commissioner, Chief Electoral Officer held a meeting, but they asked us to reduce, we reduced it. It's an admitted amount, literally, the banks are after them for, we have taken loan and spent. The government, in fact, this is money is given by the Election Commission of India. Election Commission of India has directed the state government to disperse. Learned single judge, in fact, records that note at page 142.
No, where is the impugned order?
Please, impugned order of the learned single judge is at page 18 minutes. He directs release of that amount, admitted amount.
But the direction of the learned single judge lordships will get it page 49.
14.
Why are you doing? If lordships have the contempt, not the petition.
We have got the appeal.
Please, sorry, appeal. Appeal, it's at page 140, 60, page 60. But at page 38, Learned Single Judge records the statement of the Election Commission of India that they have directed the state government to release the amount. At page 38, paragraph 6. Learned Central Government representing the Election Commission, Sharad Dodwad, would submit that the Commission has already given its free nod to release the amount and has nothing to say with the release of the amount. This is the Election Commission of India's program.
Lord, could I just have a word with the learned advocate general and get back to my lord?
Today or
No, my lord, a week's time.
But there is, normally I wouldn't oppose, but there is,
No,
the instructions are there, they are really under stress. In fact, we had filed a contempt petition. Because they said they have filed an appeal, we did not press the contempt.
20th. To be listed at 2:30.
2:30.
10 to 20th at the request of learned advocate. Learned government advocate, additional government advocate Neelofar Akbar, to be listed at 2:30. In view that learned additional government advocate will be taking instructions. Please.
oblige, my lord.
Caveat number 6813 of 24. There is
Pardon?
2 extra caveats in serial number 15, my lord.
Same.
Same.
So
6813 may be deleted.
15 and 15.1.
Yes, my lord. Caveat number 6813 of
So
24.
both will go together.
No, my lord. That is on the interim order, my lord. The caveat was.
We'll
filed on-
extend the interim.
No, my lord. The
No,
caveat needs to
what
be.
he says is not there.
Two
By
caveats.
mistake, 2 caveats have been filed. It's all right. That should not.
You withdraw one of them.
Yes, he wants to. It's all.
681.
It's all.
On that day, we'll discuss.
We'll speak. It will be reported.
List one, password matter seal number 9.
My lord had posed a query, my lord, with regard to annexure A at page 22.
Survey
My lord, yes, survey number. My lord, what has happened is they have been granted a mining lease. My lord, it is that, my lord, paragraph 3 of the writ petition, my lord, internal page 10. Sorry, my lord, I'm taking my lord through that. My lord, lease is granted in respect of survey number 1, part of Vittalapura village, Sandur Taluk, Bellary district, Karnataka. My lord, now what has happened is they have applied for, my lord, the stockyards, 2 stockyards, so that whatever mineral they have extracted, my lord, they could, my lord, store them in these stockyards. So as per annexure A, my lord, page 22, my lord gets where the stockyards are. The stockyards are at 6B/1 and 6B/3. And the name of the stockyard is also given.
Six B stockyard.
Yes, it's a stockyard, and they do admit that in paragraph, my lord, in paragraph 10 and 11 of their writ petition. Now they'll have to approach the Honorable Supreme Court because their mine has to be categorized. The Central Empowered Committee, my lord, works under the Honorable Supreme directions of the Honorable Supreme Court. So they'll have to get an order from the Honorable Supreme Court. But your lordship may permit us to proceed with the, my lord, conducting of the auction tomorrow. And the amount will be deposited in the state exchequer. If their mine is categorized as B mine, my lord, then they can apply for refund and we will refund the amount back. Theirs is a cancelled stockyard, my lord.
You have produced your mining lease,
Yes,
copy of mining lease, page 29,
Please one.
and go to page 30,
Please
part 1, area of this lease,
Please one.
where the survey number is indicated, is survey number 1.
Please one.
So then this Supreme Court order will apply.
My lords, I am not disputing the fact that the lease is situated in survey number 1. I am saying with respect to the stockyard. I have not been yet categorized. A, B, C. I have not.
They will get refund if it is.
My lord, yes, they'll have to approve. My lord, I'm sorry,
My
I'm
lords, all I'm saying
interrupting.
is that till it is categorized,
Speculation is there in this order.
Yes, yes.
Where is it? Category.
lords, we have not been yet categorized, neither A nor B nor C yet.
My lord,
We
survey
have
has
been in the
been
judgment
conducted.
itself.
Huh?
If my lords may kindly see at page
Then where
5,
is it? Five,
it
not
is
five.
clearly stated that the 7B1 category mining leases lie between the state of Karnataka and Andhra Pradesh. They require demarcation on the ground. That includes our lease at serial number 3. Till today, this demarcation has not happened.
Yes,
And it says this court's order dated when directing the joint team to prepare sketches of those 7 mining leases was deferred till the interstate boundary was demarcated on the ground.
survey is conducted, no? No, survey is conducted.
Where is the observable refund? Refund.
No. My lord, refund is not there. What I'm submitting to my lord is, my lord, internal page 4, wide report dated 3/2/2012. My lord gets it. The CEC recommended the categorization of the mines into categories A, B, and C based on the severity of the encroachment by the mines and overburden dumps. My lord gets it. My lord, now the survey that is conducted, my lord, that report will be placed before the Honorable Supreme Court. The Honorable Supreme Court, my lord, will then categorize whether the mines of the petitioners has to be categorized as A, B, and C. My lord, if it is B, then they get a refund. If it is C, my lord, then they don't get the refund. My lord, in fact, by order dated 20th April 2012, my lord, the Honorable Supreme Court, my lord, in internal page 5, internal page 5, my lord. My lord, below the caption order, my lord gets the figure 6. My lord, the second paragraph, sale of iron ore lying at various cancelled stockyards, my lord gets it, is permitted through e-auction by monitoring committee with the condition that sale proceeds not found to be involved in any illegality will be reimbursed to the respective stockyards.
My lords, all I'm saying is, my lords, I am not yet categorized. This stockyard has not been cancelled. So therefore, my lord, till I am categorized,
Should have gone to Supreme Court. In wake of this Supreme Court order, we will not grant.
my lords, what all I'm saying is that my lease has not been categorized till now. And they have made categorical submission that they will categorize it after the survey is conducted. What is the difficulty in conducting auction after my category is done, my lord?
Your survey number is included in the Supreme Court order.
My lord, survey, the survey.
Very lease included.
The survey number is included so far as the lease is concerned, my lords. What all I'm telling is that I had permits and I have produced those permits before them and told them that these are the validly excavated materials which are subgrade in quantity, and please permit me to stock it in a yard, and which was duly permitted by them. And this is that particular survey number is not included in the Supreme Court order, my lords. Now, my lords, if they auction it, and tomorrow to recover it is a Hercules task, my lords. And my category is not even done yet. I may fall under A, I may fall under B.
And my lord, there is a categorical submission before the Supreme Court. My lord, may kindly see the permits what they have given me. That is not disputed at any point of time. Then my lord, IBM has also permitted me. The permits, my lords, will get it at annexure G page 80. There are two permits which were given to me. Thereafter, my lords, at page 88 is the IBM permission for the stockyard, to maintain it in the stockyard.
My lord, that has been cancelled.
Then, my lords, at page 110, the permission was given. Then, my lords, recently Honorable Supreme Court have permitted to
Auctioning is permitted by the Supreme Court.
No, my lord.
Oh.
My lord, internal page 11 of the order of the Honorable Supreme Court, my lord, may be seen at paragraph 3, which starts with keeping in view the aforesaid position. My lord gets it.
No, auctioning of the
My
material.
lord, no, I have produced that order dated 20th April 2012, considering that the petitioner's stockyard license has also been cancelled. My lord, in the second paragraph, I have stated, I'm sorry, it is observed as sale of iron ore lying at various cancelled stockyards is permitted through e-auction monitoring committee with the condition that the sale proceeds not found to be involved in any illegality will be reimbursed to the respective stockyards. Now, my lord, they'll have to approach the Honorable Supreme Court once the CEC submits the report, and my lord, they'll have to get the mines, my lord, depending upon the categorization of their mines, my lord, then their amount will be either refunded or it will be withheld. The amount is 2.56 crores. The Honorable Supreme Court is very clear, my lord. The order, internal page 11, paragraph 2 and then 3 onwards.
My lord, these are all pertaining to C category mines. It's not pertaining to B1. We fall under that peculiar category where we have not been yet categorized.
Now this matter is coming up because Supreme Court on which date?
My lord, the survey is not complete as yet.
Survey is not complete.
My lord, we may be permitted, my lord. Anyway, the money will be with us. We can refund it back. The prayer in the writ petition is very simple.
My lords, in fact, the recent judgment of Honorable Supreme Court in the same matter, the courts have directed without following e-auction process to sell the iron ore where it is pertaining to category A and B. These all judgments, the orders which have been relied upon are pertaining to category C.
You are permitted to continue mining operation.
No, my lords, we stopped it in 2012 itself.
We stopped it in 2000.
There is,
My lords, our application is pending.
there is no question.
My lord, the renewal application is pending. Because of this survey which not been conducted because of
your-
the boundary dispute,
Your license was cancelled.
not yet cancelled, my renewal is pending. My renewal is pending, my lords. My renewal is pending because of this border issue, my lords.
When in 2020?
What will you do with the amount realized?
My lord, state exchequer, we deposited in the state exchequer. My lord, and the lease expired on 31st March 2020. Now the Honorable Supreme Court will have to decide with regard to the renewal of their lease.
My lords, my
What do
renew-
you want? You are inviting order, or you want to go to Supreme Court?
My lords, it will not fetch anything, my lords, if I go there, because my lords, the renewal is still pending. All I'm asking is that till my renewal is considered, till I'm categorized, at least not to take the auction. And my lords, if at all they want to auction also, my lords, how will I recover that amount, my lords? And it is out of due permits were taken. There are complaints filed against me that has attained finality. This honorable court have quashed those complaints that has been filed.
What is this MSTC?
Yes, my lords.
Branch manager MSTC, what is that? MSCT, page 22. Letter is addressed to MSTC. What is MSTC?
My lord, page.
Mining,
My lord, that is an e-auction platform. Government of India.
no.
Branch manager.
Letter dated 26/8/24 regarding auction is addressed to the branch manager MSTC. What is MSTC?
My lord, they are the facilitators for auction is what I'm informed.
Hard learned advocate Miss. So and so for the petitioner and learned. This is coming for the first time?
Please, my lord.
Yes, my
Learned additional advocate. Additional government advocate, Srimati Neelofer Akbar. Who appears for the respondent state and authorities upon service of the copy of the petition in advance.
Metal Steel Transport Corporation.
Finally, you are inviting order.
My lords, all I'm asking, my lords, if they agree for if they agreed in case they want to go ahead with the auction, if they can reserve this till categorization happens,
What reserve? Reserve.
this amount, if in case the auction yields some, because this is the second auction, first auction also did not happen. So if second auction, if something come, if the some bidder comes and auction is successful, let this amount be kept aside till my categorization is done.
Do you want to wait till auction take place?
My lords, not necessary, my lord.
Three options are there.
Please, my lords.
One is inviting order. Two is going to Supreme Court for clarification and order relief. And three, to wait, permit the auction to go on and wait for the outcome.
My lords, in that case, I'll opt to go to Supreme Court. My lords. I'll opt to go to Supreme Court.
Withdrawing?
Please, my lord.
What do you propose now? Tell us. It is entirely your choice. Option is yours.
My lords, my humble request is, my lords, at least not keep that money aside in case the auction yields. Subject to my categorization, my lords. At least I may have the liberty to claim that amount. Because if government themselves have
Or
agreed, my
learned
lords,
advocate.
government themselves have agreed that if I'm fall under B category, I'll be entitled to claim that amount.
So proceeding with the order, heard learned advocate Miss so-and-so for the petitioner, and learned additional government advocate Miss Srimati Nilofer Akbar, who appears for the state in authorities upon service of copy of the petition in advance. What is sought to be called in question in this petition filed under Article 226 of the Constitution is the communication dated 26/8/24 issued by the Director, Department of Mines and Geology. The communication reflects the decision of the authorities to conduct e-auction of old iron ore stock lying at the different stockyards of different parties. The auction is scheduled to take place on 12/9/24. The case of the petitioner, paragraph. Inter alia is that it is a partnership firm holding mining lease for extraction of iron ore. Covering area of 19.63 hectares in survey number 1 of Vittalapura village, Sandur Taluka, Bellary district. Petitioner is Messrs. Hindi Traders. It's further case that the respondent number 2, Director, Department of Mines and Geology, permitted the petitioner to store 3,000 tons subgrade of iron ore, lumps, LUMPS. The decision reflected in impugned communication dated 26/8/24 provides for auctioning of the said old iron ore stock of the petitioner, which is one of the five leaseholders whose old iron ore stock is also to be subjected to e-auction proceedings. At the outset, it is to be noticed from the record of the petition that identical communication scheduling e-auction was What happened to your earlier petition?
My lords, the day matter came up, by then auction had happened. So we withdrew it. I have unclosed it. Because by the time it was considered,
Scheduling e-auction
that's why, my lords, we withdrew it. That is at page
was issued by the
164.
authorities on 4/3/24. The auction was to take place on 16/3/24. The said auction notice was challenged by the petitioner in writ petition number 7950/24, which was not entertained and came to be disposed of. Also, the copy of the said order passed.
That was because the
Division
matter
bench.
came up after the auction date. It was
Figures on
continuous holiday. But that auction did not take place.
As the auction had already taken place, the petition was disposed. While the subsequent auction, e-auction notice dated 26/8/24 is again complained of by the petitioner, responding to the challenge from a learned additional government advocate. Produced copy of the order, judgment and order dated 14th March 2024 of the Honorable Supreme Court in Samaj Parivartan Samudaya versus State of Karnataka. Passed in writ petition into civil over number 562 of 2009 and other connected petitions. It was pointed out that the auctioning of the old iron array of the petitioner and other leaseholders is being acted upon in light of the said order of the Honorable Supreme Court and the directions contained therein. The aforementioned order dated 14th March 24 of the Apex Court showed that the petitioner Samaj Parivartana Samudaya had filed writ petition seeking Honorable Supreme Court's intervention in relation to the illegal mining activities and consequential harm posed to the environment in the state. Full stop. The Supreme Court referred to its judgment and orders passed in TN Godawaram versus Godavarman Hirum Palad, it is here, versus Union of India and others. And other decisions. It appears that what is CEC? Central?
Empowered Committee, Central Empowered Committee.
It appears that Central Empowered Committee was constituted and was directed to submit report with regard to certain mining leases granted by the state of Karnataka in the district of Bellary. As is evident from the copy of the lease deed produced on record of the petition, the lease was, mining lease was granted to petitioner in survey number 1. In Vithalapura, Phalapura, village of Bellary district. Admittedly, the mining leases, paragraph, admittedly, the mining leases categorized as P1 were 7 in numbers, categorized by the Supreme Court in B1 category, which were 7 in numbers, included the petitioner in the traders, and the same mine in survey number 1 had measuring 19 hectares and 63, had measuring 19.63 hectares at Vithalapura, Sandur Bellary, was mentioned in the order. The Supreme Court had directed by order dated 28/9/22, had directed the joint team to prepare sketches of the said mining leases, including that of petitioner, by order dated 28/9/22. Putting the said order in abeyance, keeping the said order in abeyance till the interstate boundary was demarcated, since all the 7 minings were located between the state of Karnataka and Andhra Pradesh. Full stop. It was recorded that subsequently the authorities demarcated the boundaries, and the boundaries were fixed. It also appears that earlier on 29/7/2011, the Apex Court imposed a temporary ban on mining operations in the Bellary district. As per decision in state of Andhra Pradesh versus Obullapuram Mining Company, OBULAPURM, into bracket P Limited, into bracket 2011, 12 SCC 491. It further appears that the Central Empowerment Committee had requested the National Institute of Technology, Surat Khal, SURAT, KHL, Karnataka, to carry out the survey at the ground level. Both the governments, that is the government of Andhra Pradesh and government of Karnataka, had suggested 4 officers who comprised the team which undertook which was the part of carrying out the survey. It is on the basis of aforesaid exercise and other details paragraph recorded by the Supreme Court in its order dated 14th March 24, that the authorities, having identified the leaseholders, and which leaseholders were specifically referred to as 7 leaseholders in the order of Supreme Court, have proceeded to have proposed the conducting of e-auction. The survey and scientific exercise was undertaken in respect of the 7 mining leases, which included the petitioner, which has led to the impugned communication for re-auction, which is a second attempt by the authorities. Not rare. It is in pursuance of the aforementioned order passed by the Supreme Court in Samaj Parivartana Samudaya Supra. Paragraph. In view of the contemplations and directions of the order of the Supreme Court, this court is not to interfere with the process of e-auction. No relief could be granted to the petitioner. At the same time, it is observed that all the post-auction rights of the petitioner shall be regulated and governed by the order dated 14th March 24, passed in Samaj Parivartana Samudaya Supra, and any further order which may be passed.
Obliged me.
Petition is not entertained accordingly.
Number 72, Mr. B.M. Arun.
That's it's been complied.
Complied with.
Please.
They have released the B2.
We have written to the KEA to allot the seat.
College with the- they are going to block the report. To release the seat, my lord, we will do it, but day after tomorrow, we'll make that.
My lords, good question. One submission, my lords. My lords, may I kindly say, take the seat matrix at annexure D, page 73, my lords. The earlier round, I was entitled to Jawaharlal Nehru Medical College, Belagavi, my lords, I was deprived of that. Now kindly see this annexure D, page 70, only for academic, this one. The seat matrix, they have not specified the seat college which I am being allotted seat. The first college is KMC Ampankatta Mangalore. They should have allotted it in terms of the orders of this court. They have allotted it to different person in the first round.
We have said that it is authority
One seat,
directed
yes.
to admit the
Seat.
petitioner to MBBS course on a seat in quota reserved for
I understand.
courts in the.
Yes.
Understand.
So you are given admission on
Yes.
a seat.
Yes.
Yes.
That the problem is only one college, my lords, I want to state because of the nature of the matter. Last college, my lords, in Mudenalli, see, Madhusudan Sai Institute, pre-education is granted medical, this one, my lords, 5 years, they have to find themselves to that. That college is a different category in India, my lords, a special category. That if that they give it, it will get into this one, my lords. Any other college that I am satisfied with, I am not asking for the first seat, my lords. I understand the gravity. They have already allotted the first 3 seats. Chikbalapur Institute of Medical Sciences, Chikbalapur, it is there, government college, my lords. If they allot it to that, I am satisfied, my lords. I will not ask for.
Your experience enough. We can't improvise anything in the.
No, that last one, I'll get into this one, my lords. 5 years binding agreement will be there for that college. That is a unique college. That clarification, my lords,
So what is this?
They have released that seat, my lord.
Sir.
One seat has been released to give it to the petitioner that. That's it.
only one thing, my lord, that college gives free education in medical, my lords, unique college in India. So Madhusudan Sai Institute of Medical Sciences. Let a poor student study in that college, my lords. Why this seat? She is from some middle class. She can afford this other college, government college. Some accommodation, my lords, I request the honorable court. See, last but one, my lords, can be reserved. They are reserving one college. I am not seeking the premier, this one. Last but one is a government college, my lords, in Chikbalapur. That we lords may kindly consider that. Otherwise, earlier I was entitled to Jawaharlal Medical College, Belagavi. I lost that one. Now I was entitled to KMC Ampankatta Mangalore. That also was not deprived. Now the choice is 4 colleges are there out of 1 college, my lords, Chikbalapur Institute of Medical, new college. That is a government college. There are 2 colleges in Chikbalapur. 1 college gives free education, a private college. I don't want that college, my lord. Let it go to, as an officer of this honorable court, I'm making a submission, my lords. Let it go to a poor student. Chikbalapur Institute of Medical Sciences is their new college. My lords may consider that, my lords, give a direction to them. I will.
The material direction, but only direction, which came to be issued by this court in judgment and order dated 19th July 24, while allowing writ petition number 24645/23 was as under bracketed portion, page 70. The aforesaid direction is brought under the contempt jurisdiction of this court for its non-compliance. It was the case of the petitioner complainant that in pursuance of the aforesaid direction, the authorities had reserved a seat for the petitioner in the MBBS course in the sports quota, but
No, they are not reserved, my lords. Now I see they have said that National Medical Council should approve that one.
My lords, may I
but actual admission was not given at that time. Full stop. Today, when the petition came up for consideration, a further communication dated 11/9.
No, last but one paragraph, it's,
Today's communication.
they have reserved right.
Further communication dated 11/9/24 was produced in vernacular language, in which, as stated and confirmed, it was given out that the seat which was reserved for the petitioner.
Has been released for,
Is allotted.
he's been released for allotment.
Is released for allotment.
We will allot it day after tomorrow.
It is further stated by learned counsels for the respondents that on the release, in the seat so released, the petitioner shall be given admission
Yes,
in compliance with the directions of this court
please.
in the aforesaid order.
My lords, may kindly
stop.
keep it on Monday, my lords.
Said communication come decision dated 11/9/24 is taken on record. In view of above,
My lords, may kindly keep this on Monday for any exigency, my lords. I will bow down to the court, any exigency, Monday, let them take a call, my lords. Because they have said the NMC has to approve the seat
Yes.
in spite of the court orders. Kindly see the last
The
paragraph.
government's view. again,
Subject to approval of NMC, they have stated.
what did you read? It is stated by learned for the Telecast.
There, but in
We have stated in the order that it is stated by learned respondents that on a seat so released, the petition will be given admission in compliance with the directions of learned single. Full stop. In view of the aforesaid communication come decision is dated 11/9/24 shall remain on record. Full stop. The respondent shall comply with the contents of the said communication dated 11/9/24 and the statement made before this court recorded as above. Please. Full stop. In above view, nothing survives in the contempt proceedings. It is accordingly liable to be disposed of. Paragraph at this stage, learned advocate Mr. So-and-so made a grievance that the petitioner is not allotted a particular college. Full stop. We are afraid that these aspects could be brought within the domain of exercise of contempt jurisdiction by this court. If any grievance subsists for the petitioner, notwithstanding the above developments, it is always open to the petitioner to raise an independent challenge as may be permissible in law and in accordance with law.
Grateful.
For which this court does not express any opinion.
Grateful.
Well, I may be permitted to file vocal for first response.
Contempt proceeding is disposed of accordingly as not surviving anymore. Yes.
I may be permitted to file vocal for the first respondent.
Learned advocate Mr. K and Mr. K
In Kerala.
and N.K. Ramesh is permitted to file his wakalatnama within 10 days.
First respondent. For the first
For
respondent,
respondent 1, which shall be filed within
1 week,
10 days.
10 days.
Grateful.
The office shall accept such wakalat.
It's mentioned matter, writ petition 26607 of 2019, Mr. Pawan Kumar MN.
For the petitioner minutes. Petition is for release of an amount aggregating to 1,88 lakhs in respect of the sale of 8,000 metric tons of iron ore which was seized from the petitioner farm. During the pendency of this writ petition, an e-auction notice has been issued for sale of 5,400. File it in the counter.
Where is it? Earlier. This is the same one of the party before Supreme. Not that auction.
Lord, I have no papers. Nothing is served on me.
You saw them.
My lords, I had filed it in the counter. I don't know where I can give my office copy to them.
Who are you? What is the name of the petition?
Krishna is a partnership firm, my lords. We have established a stock yard.
Will issue notice.
My lords, auction is today between 4 and 6.
Today
Please, my lords.
will not stay the auction.
My lords, if I may,
What is being auctioned? Old iron.
they have issued a notice for, yes, my lords.
Where is that notice? Page?
Page 12, my lords. Sorry, page 11, my lords, annexure Q.
Page 12.
11 minutes
11.
of my application.
Which application?
Application dated 3/9/24.
So this is a pending matter.
Please, my lords, this is a pending matter. During the pendency of this writ petition, an e-auction notice came to be issued.
No. Where is the IA then? This must
IA.
have been given. IA is filed.
IA is filed, my
Where
lords,
is the time?
on 3/9/24.
So you got circulated IA.
Please, my lords. IA is for stay of the auction, my lords. E-auction notice is at 11.
It appears to be again
Same matter, my lord.
same, yes.
No, my lords, the previous
it-
matter.
Name does not figure. Your Rajmal silk.
Please, my lords. 5,411 metric ton of my iron ore has been put for auction.
We will not stay anything.
My lords, the previous matter, the distinction is this, my lords. The previous matter was with reference to the leaseholders who had come before your honors. But I established a stockyard, my lords. What I do is I just store the iron ore and I sell it to further entities. I am not into the mining aspect of it. And in similar matters, my lords, orders have been passed for releasing of the sale proceeds, which has been accumulated.
That's after auction is taken.
Please, my lords, after auction. Now, this auction also, previous year as well, an auction was issued, e-auction notice was issued, but it was not successful.
What is page 7 of your application?
This is a representation which was issued by me, my lords, to Director of Mines and Geology.
What is
Refrain
this
from-
1123 is what?
11, 12, 23.
Page 7 is what?
My apologies, my lords. This was the previous representation which was given in the year 2023. Last year also an auction was issued, but it wasn't successful, my lords. This is with respect to last year's auction. The present regarding auction notice dated 26/8/24, my representation is at page 12, my lords, 38/24.
Number. This is the number. Reissue notice.
Very well.
Hard learned evidence, so and so, so and so. Notice dated on 25th of September.
Very well.
Before the next date, a copy of this petition. Entire set of these petitions shall be supplied to learned additional government advocate,
Obliged.
Ms. Neela Parak.
Please, may I request for a date to be, may I request for a date, my lords? May I request for a date to be,
Requesting for stay, like. Is you involved in this petition, like, give that, this one. No, old one. Is you involved in this interim application, is he involved in the challenge in this, and the calling in question? Is you involved and the calling in question in this interim application is about the auction notice, e-auction notice dated 26/8/24, issued by the competent authority to conduct e-auction in respect of old iron ore stock of the leaseholder of the leaseholder parties named in the said auction notice. Petitioner Messrs. Rajmal Silk is one of such party whose stock is proposed to be subjected to e-auction. Full stop. The representation,
Annexure R, Annexure R.
representation, page 7. None?
Page 12, my lords.
What is page 7?
Page 7, previous year, one more notice was issued. Previous year, one more notice was issued, my lords. So
Representation, other representatives were at page
7,
12.
12.
The representations dated 11/12/23, which was earlier representation, as well as the representation dated 30/8/24, into bracket figuring at annexure P and annexure R of the interim application respectively, along with the interim application respectively, refer to the decision of the Supreme Court in Samaj Parivartana Samudaya and others versus State of Karnataka, which was writ petition number 562 of 2009. Full stop. In that decision, the Supreme Court passed order dated 14th March 2024, issuing certain directions about formation of the Central Empowerment Committee, surveying the mines which are operating to surveying the mines which are operating to the detriment of the environmental interest, and full stop. It is a matter of record that this court dealt with identical issue in writ petition number 24632 of 24, which was dismissed today after hearing both the sides in light of observations and directions passed by the Supreme Court in Samaj Parivartana Samudaya Supra. Full stop. In the aforesaid view, no interim relief can be granted to the petitioner. Interim relief is hereby refused.
Obliged.
You must know where to stop, otherwise will be unstoppable. You must know where to stop your submission. Yes, next.
It's number 88.
Yes, 88. What is
Compliance affidavit has been filed on 3rd of July, my lord. The order
dated 6th of June 2022 is at Annexure A, page 14, ma'am. And the representation of the petitioner was directed to be considered in accordance with law, ma'am. And an endorsement has now been issued, which is annexed at Annexure R12, ma'am. It's been considered. The demand was basically for grant of 150 acres of land, ma'am. Now that 150 acres of land is a notified forest land, my lord. And it now cannot be granted to the petitioners.
So page 16 are the direction, page 16.
Yes, my lord.
So
Annexure R12 at page 177 is the endorsement which has been issued considering the two representations.
177.
7. I'm just permitted to explain brief facts.
So what is the endorsement?
Lord, what the petition, in 1959, an extent of 359 acres was acquired for a construction of a tank. Now, the petitioner's land was also subject matter of acquisition. Now, they had sought for a release of 150 acres of land, which was a forest notified land. A final notification was issued under the Mysore Forest Act. Now, that land cannot be given to them because the forest department is in possession.
They want specific land.
They want that specific land.
No, my lord, I'll make my submissions. My lord, acquisition is not in dispute, my lord. In lieu of the cash compensation, land compensation was requested and that was acceded, my lords. We did not ask for any specific land. Our only request was to grant any land which is adjacent to our village, my lord, because the whole village was submerged, my lords. So that in that view of the matter, the government took a decision that an extent of 150 acres of land, of forest land, no doubt that in the year of 19.
Where is your representation?
My lord, my representation is at ink page 93, please, my lords.
93.
93 of my petition, my lords. That is the translation.
So no demand for specific land.
But 150 acres, what happened was identified and records also reveal that it was handed over to the revenue department for distribution,
We
but
are
it
not-
was not de-reserved.
You are supposed to give some land in lieu of what the land lost.
Correct.
You give land. That's the direction. Or decide that we can't give. But don't say this is forest land and that's out of the. Just let the learner single just says that consider the representation.
Please.
Insofar as that,
If you want to say no, say no. So that he knows where he stands. If you want to give some land. But you are saying something else.
Lordship may kindly see the representation.
Let us see.
The, I have also produced it at Annexure R1 along with my compliance affidavit. Lordship may kindly.
So your order starts except 12, no? R12.
R12 is the endorsement which has been issued, my lord. Their representation, I have produced it at annexure R1. my lord.
What
Can
you said?
kindly turn to page 12. my lord. Yes. (177), I have said that request for release of this 150 acres is not possible because it's a notified state forest and it's in possession of the forest department.
Then what is not possible? That 150 acres.
150 acres, my lord, which are comprised in 3 survey numbers.
So the
Cannot
court
be
doesn't,
giv-
court doesn't say that you consider this case qua 150 acres on.
One more point, my lords. Just kindly peruse the one para before the final statement what Honorable Assistant Commissioner has made, my lords. Ink page 195, my lords.
It is,
There is-
we are on 195 only.
Please, my lords, because last para of that 195, my lords, there were multiple correspondence even to get the details as to how it has to be dealt with, my lord. There was a correspondence made to Deputy Conservator of Forest, Tumkur, my lords, wherein the Deputy Conservator of Forest, Tumkur, has specifically stated that if the application is made in accordance with law, it will be considered is what Deputy Conservator of Forest himself has given the endorsement.
So that 150 acre concept is your own creation.
No, my lord, if your lordship kindly sees the representation, now what has happened, my lord? In lieu of the lands which have been acquired, my lord, there was a proposal to grant them 2.5 times the lands that they lost. There are about 23 farmers. This extent of 150 acres of land was identified, which was admittedly a state forest land, which they also admit in their own representation, my lord. Now, this land did not come to be de-reserved in accordance with the Karnataka Forest Act. It continued to remain as the forest lands. And as on today, the forest department is in possession of the land.
Where is your representation page?
Lord, my representation starts from page 93 of my petition, my lords.
93.
93, that's the typed copy, my lords. After
You said 93.
yes, my lords.
90.
Before that, my lords.
Have you referred to 150 acres of land?
My lord, I'll just inform this honorable court how this 150 acre came into picture, my lords. Let's kindly look into ink page 72 for a moment, please.
Hmm.
It was government's decision that 150 acres be given as land compensation, my lords. And in fact, in the year of 1964, please, my lords, the revenue department has taken the position
Your land was, you lost land in what, some irrigation project?
for the construction of a tank, my lords.
Dam,
A tank,
tank.
please. Because due to some unforeseen incident, the one tank which was there in the premises locality was broken. And
4 villages were submerged. My lords.
Thank.
Could hear it. Hear it. Repeat. You want to repeat dictation? What did you write last? Pardon? Last line. Correct. Comma. Where is your endorsement? Where is the
Page 178, annexed
Okay.
R12. Translated copy.
competent authority of the revenue department has filed the affidavit along with which an endorsement dated 20th/3/24 is produced. The endorsement proceeds to discuss the aspect that 150 acres of forest land was handed over to the revenue department for the purpose of utilizing same to be allotted as alternative lands to the affected land losers. Most of the endorsement further mentions that since the land is forest land, it could not be granted. It is therefore stated that the Assistant Commissioner Tumkuru Subdivision therefore could not take any decision or action in relation to the representation of the petitioner. When learned, your additional report, General.
Yes,
Mr.
Kiran Ron.
Was queried as to why the consideration of the compliance of the direction of law in a single judge and the representation of the petitioner for the purpose of allotment of alternative land is confined to said 150 acres only, comma, while learned additional advocate general was entirely at his receiving end, comma, he however struggled to point out that the petitioner had in his representation mentioned about 150 acres land which was to be handed over and was handed over by to the revenue department for the purpose of utilizing for above purpose. Full stop. Merely because the petitioner had knowledge about such handing over of some land, and for that reason he had mentioned the said aspect in his representation. It is hardly permissible that the authorities confine themselves to said portion of land only for the purpose of compliance of the directions of learned single judge. In adverting to the discussion in the endorsement to said 150 acres of land only, and to say that the said land being forest land could not have been utilized, and therefore the authority could not take any decision with regard to the compliance of the directions of learned single judge, comma, amounted to an ingenious way of circumventing the directions of learned single judge. Full stop. The court is entirely not satisfied with the stand taken by the respondent in the compliance affidavit and with the endorsement produced. Full stop. It is for the respondent concerned to take appropriate steps to comply with the direction. Full stop. For this purpose, time is granted. The contempt petition shall be listed next on 26th of September.
One submission, if Lordship permits me. In my para 19 of the affidavit, I have also enclosed the award notice which has been issued for payment of compensation. Compensation award notice has also
We
been
do not
issued.
know how to respond to the court direction. It is your business. We are not saying that you do
For
it
a moment.
particular way, but not in circumventing way. That is the all.
No, that's not the intention.
That we are saying that it is.
May I just request your Lordship to kindly permit me to read one para of the affidavit.
Page.
Page 7. Page 7. Now, my lord, the representation I can point out to say that the demand was for 150 acres. And in para 19, I have said, I state subsequently on going through the records, it was found that the award was passed pursuant to the acquisition of land. Copies of the award notice issued in the year 1959 is produced herewith as Annexure R13. The said award notice discloses the name of the project work, award order dated, name of Katedra, details of land, total extent land acquired, amount of compensation claimed per acre, amount of compensation fixed per acre, interest component, total compensation to be paid, the funds from which compensation is to be paid. Accordingly, notices have been issued to the complainant.
We can only say it will be. We can only say that it will be open for the respondents to pass the appropriate order. What order we do not know.
True, my lords.
But appropriate order.
Because that
yes.
award,
Only
subsequent
thing
to
that
that award,
he must know where he stands.
please.
Yes,
Because
sir, I
subsequent to award,
understand.
that 150 acre land has been handed over.
We'll see.
It's all subsequent actions. That award was never implemented. I'm now neither having cash compensation nor land minutes since 1959. And in one more submission, my lords.
See, we are very clear to you also.
Please, my lords.
We only want that you must know your stand.
Correct, my lords.
If you are required to challenge the endorsement or that decision, you
I
must be entitled to.
Yes.
That space should be given to you.
Yes, please.
Nothing more we are saying.
Highly obliged. Much obliged.
80, 89, 90, 91.
All are connected.
In all this,
That is for them, whatever options you have, you consider. But this endorsement, we are not approving. We don't find this to be a compliance of the directions. That's all.
Lord, I just submit, Lord, Lordship permits.
No
The-
further advice.
Lord, my only request is, Lord, the two representation, if I'm permitted to read, my Lord.
You find out, Mr. Counsel. You are capable of finding out the ways and ways,
All right.
which are legal in contempt jurisdiction. Yes.
To 91.
Up to 91 connected matters.
All are connected.
Much open.
192. Idulata.
What is it?
Let's, rule,
Why it is kept at 230?
your lordships, felt that it could be disposed because it's a short point, my lords, that is involved in this matter. Rule 3A, my lords, of the Karnataka minor mineral concession rules provides for removal of rocks that is found in agricultural land for leveling of the land, my lords, or for betterment of agriculture without obtaining quarrying license or quarrying lease, my lords. These are small land holdings where they can remove. My lords, the petitioners, in both the petition, my lords, had approached this honorable court in the last occasion. This honorable court had directed, my lords, them to issue transport permits, my lords, for us to remove the material. My lords, by the time that they took 2 years, my lords, the rule was amended.
Are you ready or not?
Let friend finish, my lord, I'll make my submission.
Lords, your lordship,
Petitioner wants working permission for 12 months to extract the
kindly see
stones.
rule 3A, my lords,
So these are the stones which are
which is there in my agricultural
West,
land.
west.
Kindly see annexure B1, page 29. These are all small rocks which are found in the agricultural land belonging to the petitioner. This is just hardly 38 guntas, my lords, of land, lesser than 1 acre.
Page.
Page 29, annexure B1. These are the kind of rocks that are found in the agricultural land, my lords. So they have to be removed and the land has to be leveled for betterment of agriculture. That's from 2017, we're giving representations. At that point of time, my lords, the Department of Agriculture was called upon to give an opinion if these stones are removed, will it better the agricultural field, my lords. It was said in the favor of the petitioners. Rule 3A, my lords. I've extracted it in my petition itself.
So land from where you want to remove is agricultural.
Yes, it is my agricultural land.
Your
It belongs to me. Yes, yes, my lords.
It is adjacent to some mining lease.
No, my lords. My lords, these are all
My lord,
small. There is no mining act or quarrying activities, my lords.
Then, madam, what is the difficulty?
My lord, the petitioner says, my lord, in a writ petition that her two daughters, my lord, paragraph 1 at page 6. The first sentence, my lord.
They are joint owners.
Yes,
They
my
are
lord,
joint-
now one of the daughters has become a major, S.P. Sahana, and she has given a letter, my lord, to the senior geologist, requesting the senior geologist not to issue any such permit, my lord.
This I don't know, my lords. This I don't know. My Leonard never told me. I spoke to her in the afternoon also. She never told
Due
me.
to,
I like to
Okay.
take you by surprise at times.
Yeah, shock. It's more of a shock. Surprise is more nice. Surprise is more nice, my lords. This is more of a shock. Anyway, I'll take that.
no, you are. Yes,
My lord, in a lighter vein, my
Akbar
lord.
wanted you to,
I know. My lords, I have nothing
Not in a
against.
lighter vein.
I know,
In a
her-
lighter vein, I just got it just now, my lord.
I know her.
Said only a surprise, but you are shocked.
True, my lords. I'll look into that matter, my lords.
Please
The-
find out.
I'll find out that. But the connected matter also is similar, where I'm sure there is no joint
There's a
ownership.
little problem.
20th.
Yes.
20th.
Obliged.
I'll look into what this is, my lords.
Next. Now we continue further. Oh, five. Go back. After concept.
Great.
16.
Lord, I appear for the appellate in this case, Lord. Lord, there is a delay of 2 days, my lord. There is a caveat. I have already served a copy on the other side. my
Who
lord.
appears?
2 days.
Yes, my
she
lord. My,
appears.
my lords, few of them I have filed my caveat. All of them are not there, my lords, if I'm right.
Yeah, it's okay. This is the one which has come up now.
No, no,
The
no.
common order in 3 cases.
No, no. This, sir, all the
No, no.
respondents are, I've not represented all the respondents,
Oh, I see.
if I'm right.
Caveat is on behalf of,
Few of them, sir.
but then she in fact appeared for all the petitioners, my lord, in the writ petition.
What is it? This can wait. This can wait for some time. We'll take up on 27th.
My lord, only problem is, now, my lord, what the learned single judge has done is, my lord, learned single judge has propounded a new theory saying that whenever I want, employee can ask for promotion. And after 6 years, he can say, I don't want promotion, put me back.
We'll
And that
see
is
how-
what he has done. My lord, kindly see page 101. And now, my lord, I am flooded with, my lord, representation from all those who are continuing in service and who have retired with a representation saying that give us a similar relief. My lord, para 101, page 118, this is the relief that has been granted by the learned single judge. Lord, 8 years after the promotion was accepted, my lord, they now say that please put us back. We want reversion, which is unheard of.
We'll consider 27th. We'll consider.
Very well.
Yes, that's.
ಅಲ್ಲ, ಅದು ಇನ್ನೂ ಬಂದಿಲ್ಲ.
To Shekhar L. 17. Shekhar.
Next.
Number 18.
My lord, in this case, the government land, my lord, it has been reserved for Dhobi.
Relay is condoned. Anybody appears?
Allowed. Yes, my lord, maybe allowed.
Delay of 10 days is condoned. Application is allowed. Merit fit shall come upon board on 30th September. Notice, it is first time, and notice returnable on 16th October. Yes.
Number 19.
This is a writ petition filed challenging another writ petition, and the learned single judge just passed some orders. Now, my lord, there are 2 orders. One is that page number 30, which was the original order. And the another is the interim order which I had impugned before my lordship. my lords.
Again, you have come, this Muthoot Finance. You come and you bring party in person. We'll bring same part in. What is the order? Which is the order?
My lords, the original order, my lords, it was passed by the learned single judge in WP number 8812 of 2024. My lords, the relevant portion in page number 30. Para number 4. May I read, my lords?
So what do you want?
Now, my lords, now there are two orders are there. The writ petitioner says that while passing this order, he was not heard and filed another writ petition challenging this writ petition. The learned single judge entertained that and passed another interim order. But if he is assuming that he is agree.
Notice written.
Grateful.
22nd October.
This is number 20.
My lords, for the petitioners, we received a copy of the MOU just yesterday. We were served with a copy, my lords. As for the instructions, I would seek some time to go through the MOU and revert.
24th.
They have already reverted, no problem. You have it on 24th.
24th not available.
They have already
my lords.
reverted, my lords.
Uh,
To our MOU, they have given a reply.
we haven't,
One of the petitioner has reverted back, my lords. Any day convenient to my lords,
24th.
please.
my lords, 30th of this month.
My lords, at the earliest, my lords, because
17th, my lords.
30th.
Yes.
30th is almost
in
last day of
please, because
Or 17th, my lords.
17th. This
17, yes, my lords.
this 7th. 20th.
My lord, the senior counsel engaged in this matter is out of town on 20th, so.
Not on town, not in town.
My lords?
Council is not in town.
Yes, my lords. The senior.
Up to
From 18th to 26th, my lords.
27th.
Please, my lords.
please. Okay.
Number 21. Manjunath BS.
Lord, appear for the complainant.
There was a direction, my lords.
My lord, they have filed a compliance affidavit, my lord. In that, they admit that I have filed an application in the year 2000.
Lords, there was a direction to produce the list of pending application with respect to ex-serviceman quota, my lords, land grant. So therefore, I have produced the entire list, my lords. The application filed by the appellant is in the year 2016. It is at serial number 101. And before the application, there are 100 applications.
You are required to produce that.
I have produced.
My lord, in their affidavit, they admit that I had already filed an application in the year 2000, my lord. They're admitting that it is there.
It is there, say, my lords, not.
My lord, also.
It is they who have said that we have already filed in 2000 and now that land was not granted. Now we are making another application in 2016. It is their application. I can demonstrate. I've produced here.
My lord, also they have annexed the list of applicants, my lord. In that, no one has mentioned the survey number to which I have asked, my lord. And
There are
also,
many ahead of you.
Please, my lords,
Many
that is.
seniors.
my lord, I had applied in the year 2000, my lord. And they have rejected my application in the year 2009. From time to time, I have been applying for this granting of land.
2009.
My lord, I had applied in 2000, but they have rejected my application in the year 2009. They have taken that long years to reply.
It is on record.
My lord, I can submit it, my lord. I grant an opportunity to file rejoinder along with the other documents, my lord.
You show that some application was filed before 2016 and it was rejected. And was rejected.
Yes, my lord.
You produce that.
I'll produce rejoinder.
When do you want?
Maybe a week's time, maybe granted. I'll.
Governor Advocate Miss
CM.
Ketki.
Chetana.
Ket-
Chetana.
Ketki.
Chetana.
So and so, so and so. 6 time. 10/2. Which date?
So, my lord.
Which date? Which date?
Date.
Date. Lot of weeks time.
18th, my lord.
18th. Then 20th.
Okay.
22 urgent. Number 23. To Naveen Chandravi.
For the petitioners, my lord. On the last occasion, we were directed to serve a letter to the respondents. We have done that, my lords, and yet the government is yet to reply to the letter, my lords.
But affidavits are ready, my lords. We'll file it course of the day. Here again, there was a direction to reconsider the application along with the valid RIC valid numbers, my lords, which we have done. The entire exercise has been redone, my lords, throughout the state. Our affidavits are ready, my lords. We will file it.
File it. 25th.
27th, my lords.
25th.
My lords,
Learned additional advocate, government advocate, Ms. Pramod Kishan wants to file reply, which may be filed in the registry. Full stop. The petition, the proceedings shall stand over to 25th of September. Yes, next.
my lords, the request on 27th, my lords, the senior counsel.
27th September.
Please, my lords.
Number 24. Petitioner, I filed an application for the withdrawal of the deposited amount, my lordship.
Which is that 50,000?
50 lakhs of rupees, my lordship.
50 lakhs
Yes, my lordship.
for 50,000?
Oh, my lordship, 50 lakhs, my lordship.
Oh.
This petition has been disposed of in the year 2006, my lordship.
So it is amount towards what?
Are subject to the interim order granted by this honorable court, subject to the conditional order, my lordship. Accordingly, petition number 1 has deposited 50 lakhs rupees, my
Now the
lordship.
petition is disposed of?
Disposed of on that day. Because in with view to file a appeal before the apex court, my lordship, by file the memo,
Who
but
appears?
but oversight, it has not been mentioned on that.
Who will appear?
University. The petition has disposed of in the year 2nd December 2006 itself only. With a memo has been filed to prefer an appeal before the apex court, my lordship.
So therefore.
Interim order has been passed in 20th/6/2016, my lordship. (28/6/2016), last para, my lordship.
Oh, let allow.
Yes, my lordship.
My lord.
Who will record your appearance? Yes. Next.
Number 25, Mr. Dinesh, yes.
I appear for responding, well.
Respondent. We let it go after holidays. Next.
Number 26, Mr. Chandrasekhar PV.
In this matter, I appear for the complainant in 26.1, my lord. And 26, they have preferred a writ appeal. I appear for respondent number 2 and 3. They have filed an application to recall the order for dismissal for non-prosecution. It may be allowed, my lords.
it's on non-compliance of office objection in writ appeal number 1382, my lords. That is the.
Number 26.
Please.
All right. Restoration application is allowed.
Please.
Very well. May I request for a date, my lords, after vacation? May I request for a date?
Petition may go after vacation, 22nd October,
22nd, there's some inconvenience, my lord. 21st or 23rd?
23rd of.
Great. 23rd.
23rd. Number 27. Appearing for accused, my lord.
Filing
Majority
compliance
clear?
affidavit, my lord. Respondent.
Yes, my lord. Accused, my lord.
Compliance affidavit.
Compliance
25th of September. File in the register.
Yes, ma'am. Number 28, Mr. Sundaresh HC.
My lord, I appear for the accused number 3.
Accused, no.
My lord,
complainants. What do
we
you
have
want?
filed a review petition.
File in the registry. 30th September.
my lord, the one submission. My lord, in serial number 28, one submission, we have filed review petition, my lord. Notice has been issued until disposal of our RP. This contempt may deferred, my lord.
On that day, will.
Please.
Number 29. Adinarana.
Sir, for the BBMP, this. My oral instructions are the order has been complied with, the representation has been considered. Maybe
File your compliance.
Yes, ma'am.
When do you want?
A week's time.
24th.
Great.
Number 30, Mr. Sampath A. I appear for the
Sampath?
accused in the matter, my lords.
Yes.
I appear for the accused in the matter, my lords. My lords, the matter, may I make a submission?
Please, Sampath. Yes, you are for respondent.
Yes, ma'am.
I appear for the accused in the matter.
Pardon?
I appear for the accused in the matter.
Both are for accused, so
Please.
send out to 24th of October.
Number 32. Number 32, I appeal for complainant. Regarding non-compliance of the single page order, I filed a contempt. They are supposed to pass an order on affiliation on August 8th itself. Now,
Who appears?
Annapurna,
Not here. 27th.
my lord, there's urgency. Admissions are going on. Without affiliation, it's very difficult for the.
Admissions are going.
Yes, sir, admissions are going on for the students. Academic year is already commenced. They are taking the court order very lightly. They are not, almost 1 month is over. August 8th, they are supposed to pass the order, compliance order. Relevant page is at,
Listen to which course?
relevant page is, this is the nursing course, BSc nursing course.
Tomorrow come to.
Much okay.
Tomorrow to be listed at 2:30. Inform the others.
Great. So 33 urgents, number 34. So only there are 14%.
Good afternoon, Your Honor. The respondent 3 filed a response. I filed a rejoinder, and subsequently I have filed a few memos. And on a daily basis, there are reports in the press about the poor performance of BESCOM. And
I don't know what is BESCOM, what is poor performance. You explain the subject matter.
pardon,
Explain us what is the matter.
this is about a poor supply, power supply by BESCOM, and
We do not.
requesting that
My lord, in PIL
yes, PIL requesting that the government consider reforms like in Delhi and including in Ahmedabad and other places, essentially privatization. Essentially privatization according to a proper
What is the controversy? What is
poor
the
power supply, Your Honor.
What poor power supply?
I mean, in fact, this morning also when I
What
came,
court can do in poor power supply?
yes, this morning also when I came, it was the genset we were
We
running
are not
on.
running power company, Mr. Party in person. What court can do in this matter?
What?
We are not running any power company.
No,
We
correct.
can't do anything if
No.
power supply is poor.
No, the request to the court is to direct the government to reform themselves, reform the power company to supply excellent
They
power
will
supply.
reform themselves.
Pardon?
They will reform themselves.
That, I mean, I have been,
All at formulative submissions.
I have been at this requesting the government from decades, and they are not doing anything. That's why I have come before you, Your Honor. Like I have stated, between the apartment complexes in the,
File the counter.
I filed my,
Where is that counter?
it was filed on 25th of June 24.
You are
And-
for?
I appear for BESCOM in this matter,
BESCOM.
respondent number 3.
and I filed a rejoinder also. Your Honor.
25th of June.
Yes, my lord. My lord, in this counter, I have stated the various measures that respondent 3 has undertaken over the years to ensure that today, in a
particular day, there is uninterrupted power supply for almost 23 hours and 47 minutes. The prayers that are being sought in this writ petition cannot be granted. He wants the electricity supply system to be privatized. That will have huge ramifications. That cannot be done in this writ petition is my respectful submission.
Your Honor, you are aware there are cities in the country where the power supply is under PPPs. Delhi is the latest example. And they are giving 100% reliable power supply, whereas we are consuming something like 11 million liters of diesel every year, Your Honor. I have got the computations. I have made it. I was the vice president of the Bangalore Apartments Federation. I have made a computation. It works out to about 11 million liters of diesel every year we are consuming for gensets. Whereas in a city like Delhi, you don't require
about
1 liter of.
My lord.
Where is the prayer of privatization? Where is that prayer?
In the petition,
Yes, formulate your submissions. What is the first submission? Proceed. Proceed, Mr. Party in person. What is your first submission? Formulate your submissions.
Pardon, your
Formulate your submissions.
that the government, reform reform the BESCOM, the power supply company.
That's all.
Yes, and provide us reliable power supply, 100% reliable supply, like it is already happening in cities like
First is
Delhi.
to direct the government to what?
To supply 100% reliable power supply, reliable power supply. Just like it is happening already in cities like Delhi, Mumbai, Ahmedabad, Surat, Kolkata, Greater Noida, and other places. If BESCOM by itself cannot do it, there are companies join with form a PPP like it has happened in Delhi. And Delhi, even after allowing for 200 units free, they are recording profits and the government is the biggest beneficiary of it. Because they hold 49% equity in the power supply company.
Then?
Yes, that is it, Your Honor.
That's all. Yes.
my lord, the prayer relating to privatization is in page 16 of the petition, my lord. He wants BESCOM to be privatized.
Prayer 2, your prayer 2.
Prayer 2.
Yes, because private sector is doing very well, Your Honor. And Delhi model is excellent. Because it is a PPP prayer.
Prayer number 2 in page number 16, my lord.
Page number?
16 of the petition.
Then prayers are also at page 25. Which are the real prayers?
In the copy that I have been served, it's at page 16, my lord, the prayer.
Page 19 is the prayer. Issue a writ of mandamus directing government of Karnataka to prepare a plan for making
Yes,
BOSCOM.
yes, my lord.
Same?
Same, my lord, same.
The second one.
Delhi Odisha model as already
Yes, my lord.
stated in 9. In fact,
The last line of that prayer, committed to privatization of distribution.
where is your prayer? Where are your prayers?
My prayers in the petition itself, Your Honor, the last page.
Read your prayers. Yes.
Yes, wherefore, it is most respectfully prayed to this honorable court, be pleased to issue a writ mandamus directing the government of Karnataka to prepare a plan for making BESCOM, as also other ESCOMs, capable of providing clean, pollution-free, safe, affordable, and uninterrupted power supply. In view of the fact, number two, in view of the fact that the state has not been able to do so all these years, as suggested at one above, issue a writ of mandamus to the government of Karnataka to seriously consider restructuring the entire distribution system in the state, perhaps along the lines of the most successful and equitable Delhi and Odisha models, as already stated at serial number 22 above. In fact, until a few years back, if you went to the KERC website, under reform efforts, subpara preamble, you would find mention of Karnataka government itself having committed to privatization of distribution as far back as in 1997.
We'll continue. When will continue? Tomorrow or any other day?
Pardon?
We'll continue the hearing
Tomorrow?
whenever you want.
No, tomorrow I am tied up, Your Honor. Day after tomorrow is fine.
You're going to Supreme Court.
I'm playing
Tomorrow
around.
you're not here.
I'm playing around a golf with the ex-Chief Secretary, Your Honor.
Tomorrow you are not here.
Pardon?
Tomorrow you are not here.
I'm in Bangalore. I told you I'm playing around a golf with the ex-Chief Secretary. I'm playing around a golf with the ex-Chief Secretary, Mr. Mishra.
Playing golf.
When you will play here?
Your Honor.
20th.
No, 20th is my birthday, Your Honor.
Then we'll not take it.
If you issue your order on that day, I will be most pleased to accept it.
No, you enjoy your golf and then birthday, then any other date. When do you want?
Day after tomorrow is fine.
That may not be fine, therefore. 24th will do, 24th.
24th is fine.
24th will continue. Do you complete the arguments and then you complete?
Yes. Lord, next matter, serial number 35, my lord.
Yes.
Serial number 35, my lord. It's a public interest litigation, my lord. In fact, illegal squatters have been occupying a earmarked public park, my lord. Pungent smell coming from that space, and localites are made to stay in a most unhygienic condition, my lord.
With your lordships, kindly serial number 76, my lords. Your lordships had orally observed to maintain equities, my lords, but in violation of that, the respondents have supplied about 20% of the order already, my lords. There's an urgency. If your lordships may have the matter on Friday in the 2:30 list, would be grateful, my lords.
Respondent number 3, my lords.
Friday, what is that urgency?
Please, my lord.
What is the urgency for Friday?
My lords, they are trying to supply the entire order in violation of your lordship's oral observation. Your lordships had directed them to maintain the equities until the next date of hearing, my lords.
So far, no such directions has been issued, my lords. If may submit, the appeal is preferred by a impleading applicant to the writ petition, who is an unsuccessful bidder. And now the transaction of supply is between me and the respondent number 2, my lords.
18th.
Please, my lords. Please, my.
Be post 20th, same man, respondent.
20th.
Any day post 20th.
20th.
20th, 21st.
21st. 21st is also working.
The sitting day. Might it be 23rd if your lordships are?
There's an
23rd.
urgency, my lords, 21st. If your
We're
lords.
advancing day by day.
No, 21st is a Saturday.
My lords, they're trying to complete the order and that's
Your
the.
birthday.
I might not be.
21st is your birthday.
I'll have to formulate one for that.
All like 23rd.
23rd. Wait.
Grateful.
Yes, Mr.
Serial number 35, any date may kindly be released, my lord.
1 second.
35, next matter on public.
77, my lord. Your lordship has directed notice on the respondent.
I'm the respondent one, sir. I'm the respondent one.
Notice has been served. Time is still yet to be served. My lord, they have not represented.
In the meanwhile, my apprehension is that the bank might take physical possession of the property from me because I was residing in the particular property. Interim order may be granted till the next day. Any day your lordship may have it. I am ready to understand.
Sir, the brief of the case is very simple, sir. The property actually belongs to my
Tomorrow
mother.
will take up. Tomorrow will take up. Tomorrow.
Sir, not tomorrow, sir. Tomorrow I have one more case, sir. She has put one more case on me for
Tomorrow at
divorce,
2:30.
harass, dowry and
Give
other.
me read.
Well, it's serial number 53.
Tomorrow at 2:30.
Please.
Tomorrow, 2:30.
Well, it's serial number 53. I'm for the complainant in this matter, Malad. A date may be fixed in this matter. I filed this contempt.
Get the date, any date.
Great.
Madam, serial number 35 ಏನಾಯ್ತು ಏನಾದ್ರು ಅಂತ